Yes.
My lord, I beg to mention item number, my lord, 23 to 27, my lord. For password. My lord, I beg to mention item number 23 to 27. For password.
Home guard matters.
My lord.
When do you want it?
My lord, after 25th April, my lord.
A prayer is made on behalf of Mr. H.R. Chaudhary, Learned Senior Counsel, for an adjournment in the adjournment on the ground of personal inconvenience. Prayer is, have you informed? Prayer is not objected to by the Learned Counsel for the response. Accordingly, registry to list this matter again on when?
Not after 25th April, my lord, on any day.
On 28/4/2022. Matter be not considered as a further and or tied up matter with any further.
May it please your lordship. Lordship, I beg to mention item number 32 with the consent of the other side.
Why?
Lordship, the standing counsel for the bank is not present today. I'm for the respondent number 427, your
Bank of, who is the counsel?
A. Chetia.
What happened?
Is not well, lordship.
A prayer is made on behalf of Mr. H. Chetia, Learned Counsel, appearing for the respondent number 427, with the consent of the Learned Counsel for the petitioner, for an adjournment in the matter on the ground that he is indisposed. Prayer accepted, registry to list this matter again after.
Lordship, a date may be fixed.
After 3 weeks on a date to be fixed.
Lordship.
Please, lordship. My lord, I am praying for listing 2 matters, lordship. Right. May I please, madam?
Yes.
With due consent from the petitioner side, I beg to mention item number 37 and 38, my lord.
How did you take the consent?
Our phone, my lord.
Over phone.
Yes,
No, it was
Lordship, I
peacefully
fear-
taken.
Item number 37.
It was peacefully taken.
Yes, my lord.
Did he put pressure on you?
No, no.
Lordship, in item number 37, my senior Mr. P.D. Nair name is not being reflected in the consent.
Will reflect it. For the respondent.
No, no, my lord.
Petition.
We are petitioner.
You are respondent.
Yes, my lord.
You are appearing for respondent number?
Respondent number 6 to 11, my lord.
Oh, you're newly.
Yes. No, my lord. Item 7, I am caveator, my lord. And 19 and item number 38, I am going to file number for the respondent number 10 today, my lord.
On the prayer of Mr. P.D. Learned Counsel appearing for the item number 560. Respondent number 6 to 11.
6 to 11, my lord.
11.
Item number 37,
Why you want to file an affidavit?
affidavit, my lord.
Mr. So-and-so Learned Counsel appearing for the respondents number 6 to 11 is that he be granted further 3 weeks time to file an affidavit in matter on behalf of the respondents represented by him. Prayer is not objected to by the Learned Counsel for the accordingly registry to list this matter again after 3 weeks along with WPC number 6936/2025 by reflecting the name of Mr. P.D. Nair as the counsel for the petitioner in WPC number
Item number 37.
WPC number 560/2026.
In the 38, I am going to file color number 2.
Highly authorized. Thank you.
Yes.
With the consent of the other side, my lord, I beg to mention item number 30, my lord.
13.
The respondents filed their affidavit in opposition day before yesterday, my lord. By tomorrow Monday, I will
13.
file.
13.
But 30, my lord. The respondents filed their affidavit in opposition day before yesterday. I need to file my reply, my lord. It is already ready.
Record. Okay. Mr. R.S. Mishra, Learned Counsel for the petitioner, prays that he be granted how many?
By Monday, I can file. Can we take up on Wednesday if lordship permits?
Prays that the matter be taken up on 6/4/2026 to facilitate filing of a rejoinder to the affidavit filed by the respondents in the bill. I accepted, registry to list this matter again on 6/4/2026.
Deeply obliged.
May I please your lordship? Lordship, I beg to mention item number 31 and 41. We have already given adjournment slip with consent with other side for adjournment for today. My senior is out of town.
On the behalf of Mr. A.R. Sigda,
Yes, my lord.
31 to 41.
41.
Prayer is made on behalf of Mr. A.R. Sigda, learned for the petition of government in the matter. In court. Prayer is not objected to by respondents. Accordingly, registered to list those after 2 weeks on a date to be fixed by 31 on Belek, might be 41 on Belek.
Yes, yes. May it please your lordship. Lordship, with regards to item number 2 of the daily list, we had circulated an adjournment request, your lordship. My senior Mr. K.N. Chaudhary is indisposed today due to a
A
personal.
prayer is made on behalf of Mr. K.N. Chaudhary, learned senior counsel, for an adjournment in the matter on the ground that he is indisposed. Prayer being not objected to by the learned counsel for the respondents, the matter stands adjourned. Registry to list this matter again.
Which Monday or Tuesday? After vacation, your lordship. It will be motion week from the note.
Motion will. On 21/4/2026.
Lordship. But when interim,
Interim order passed earlier to continue until next date of it. It's that matter where
lordship, regarding the Dag and Patel.
target, they have not filed any.
They have not filed. Lordship.
Or should we ask them to file a response in that matter?
That can be done.
Do one thing, be here. Not
Lordship.
now. I'll finish up the motion matters
Lordship.
to order the one again. We'll not pass any orders. We'll only ask them to get that. Otherwise, this matter cannot be taken forward.
Lordship.
You be here when the matter is
I'll-
done.
May it please your lordship.
Yes,
I beg to mention item number 28.
28.
Kindly adjourn the matter for the day. Mr. G. Portolo is on leave.
Hmm.
We have circulated the adjournment slip also.
Go order to same. D. Bodley, person in court. Not objected to by Mr. S. Count, learned counsel for the petitioner.
The date may be fixed after the BU vacations, man.
Oh, it will come. You make a mention after 2 weeks, huh? Yes.
May it please, be clear. With regards to item number 44 with concern of the other side, my lord, my senior Mr. Mondolo is out of station. May it
Oh,
please-
his nomination has been through.
Yes, my lord. he
Oh,
says
very
my
good.
list, yes.
44. MU Mandala. Pressing personal inconvenience. Yes.
Fabulous, my lord.
Sure. Why are you withdrawing?
My lord, I've been instructed, my lord, I've been instructed to withdraw.
Mr.
May Islam.
M.A. Islam, learned counsel for the petition on instruction submits that the petitioner desires not to press the writ petition any further, and accordingly he prays that the present writ petition be permitted. Accordingly, he prays that he be permitted to withdraw the present writ. Prayer accepted. Writ petition stands dismissed on withdrawal.
All right, man.
Yes,
A matter become infectious, your lordship. Relief has been granted.
the
Yes,
thing has been granted.
Yes, lordship.
Very good. 2 lakhs granted.
Yes, lordship.
Heard Mr.
Yes, I have.
S.I.
Akan.
Khan, learned counsel for the petitioner. Also heard Ms. N. Bordeloy, learned standing counsel, Revenue and Disaster Management Department, and Ms. M. Thorman, learned government advocate. The learned counsel for the petitioner submits that the ex gratia amount of rupees 2 lakhs as claimed by the petitioner in the present writ petition has since been authorized to the petitioner by the respondent authorities, and accordingly he prays that the present that no further live issue. Accordingly, he prays that the present writ petition be closed as having become infructuous. So, in view of the submissions made by the learned counsel for the petitioner, the present writ petition stands closed as having been rendered infructuous.
Fabulous.
Pleasure.
On the last occasion, you also wanted to look into the act, my lord.
No, that day I was not carrying this book. Oh, but that act, huh? This is in the other one. All this,
Hello, what could you say, huh?
Wait a minute.
I've seen it, Mr.
It happened.
Mr. Saraf, I've gone through. I've gone through it, don't worry.
My lord.
Now, the issue here is that your case would emanate from the plea that the notice was 16/9, but you received it on 14/10 on WhatsApp. This was not accepted fully by the Commissioner Appeals, but he did not go into it. But there is an observation. The third line from bottom at page 65.
Well, my lord,
The appellant has not submitted any cogent reason that can justify condonation of this delay. Whether it is in the context of that 2 months or also the 3 months. It cannot be the 3 months.
no, my lord, it is only for the 1 month, my lord.
1 month. That plea has not been taken. That provision. Yes, what do you say?
And in the, my lord, in the condonation of delay, as you also are aware, I know that, say, my lord, that 1 month is there and when he has explained. then
No,
the-
from the materials that are there, if it is taken as 14/10/2022, at least 1 day before the
My lord,
limitation period,
And
the
when the-
appeal was filed along with the
and
amount.
when the condonable period is there, then, my lord,
The provision is there, Lordship.
Okay, but Dr. A. Saraf, learned counsel for the petitioner. Also heard Mr. R.P. Moore.
JP Moore.
Huh?
JP Moore.
JP Moore, learned counsel, appearing for the
On behalf of
on
FKT.
behalf of Mr. S. Setia, learned standing counsel, CGST, right?
Lordship.
The petitioner in the present writ petition has assailed. S. Chettiar. It's a Chettiar. We'll interfere with that, send it back to the Commissioner Appeals, let him consider the condonation application on its merits.
Lordship.
Huh? Writ petition has assailed and the order in appeal dated 20/12/2023 issued by the Commissioner bracket Appeals CGST, comma, Gauhati, dismissing the appeal of referred by the petitioner against the order passed by the assistant order in original dated 16/9/2022 passed by the Assistant Commissioner CGST, comma, Bongaigaon Division, Dhubri, on the ground that the same was barred by limitation. Also, the petitioner herein being aggrieved by the order in original dated 16/9/2022 passed by the Assistant Commissioner CGST, Bongaigaon Division, Dhubri, had instituted an appeal against the same before the Commissioner Appeals CGST, Gauhati, on 10/1/2023. So, the petitioner, along with the said appeal, had preferred an application for condonation of the delay occasioning in instituting the said appeal within the limitation as prescribed under subsection 3A of section 85 of the Finance Act 1994. Also, the petitioner, along with the said appeal, had also deposited the requisite payment. The requisite, what do you call it? Requisite payment? I had also made a pre-deposit of the requisite amount as mandated. Also, the petitioner in his delay condonation application had contended that although the order in original was issued on 16/9/2022, but the same was in fact served upon the petitioner only on 14/10/2022. In 2022. Also, the Commissioner Appeals after considering the contentions raised in the appeal memo, proceeded while the impugned order dated 20/12/2023 to reject the application, the condonation, to reject the contentions raised by the petitioner in the condonation application, and proceeded to hold that the appeal was so instituted on 10/1/2023 beyond the period of limitation prescribed under the provisions of subsection 3A of section 85 of the Finance Act 1994 and dismissed the appeal. Also, Mr. Being aggrieved, the petitioner has instituted the present writ petition. Dr. A.K. Saraf, learned senior counsel appearing for the petitioner, at the outset, after referring to the conclusions drawn in the matter by the Commissioner Appeals, has referred to the provisions of, by referring to the provisions of subsection 3A of section 85 of the Finance Act, has submitted that although the said provision mandates a filing of an appeal within 2 months from the date of receipt of the decision or order of such adjudicating authority, wherein such order is passed after the Finance Bill, 2012 has received the assent of the President, and it relates to service tax, interest or penalty under this chapter, submits that the Commissioner Appeal, while considering the condonation prayer of the petitioner, prayer for condonation of the delay occasioning in instituting the connected appeal, had only taken into consideration the main provision of section 3A, but had ignored the provision sub-proviso thereto, which had further extended, which permits the Commissioner of Appeal, in the event she is satisfied that the appellant was prevented by sufficient cause from presenting the appeal within the period of 2 months as prescribed under subsection 3A, to present the same within a further period of 1 month. Dr. Saraf submits that the appeal having been received, the order in original having been served upon the petitioner on 14/10/2022, the appeal so instituted on 10/1/2023 was within the extended period permissible as per the proviso to subsection 3A of section 85 of the Act of 1994, Finance Act 1990. Accordingly, he submits that the order passed by the Commissioner Appeal, having been so passed without taking into consideration the relevant provisions of law, the same would not mandate, the same would not be sustainable and would mandate an interference from this court. Anything more is required, Martin?
And only one prayer will be subject to lordship consideration. Lordship said that it will be remanded back to the Commissioner. Instead of that, my lord, if your lordship may direct that the appeal may be...
You'll have to withdraw, you'll have to then...
No, the appeal may be heard on merit without condemnation.
No.
Otherwise, what will happen again, my lord?
We'll bind them. We'll bind them. Mr. S. Chetia, learned counsel for the respondents, learned counsel appearing for learned standing counsel CGST appearing for the respondents, has fairly submitted that given the facts disclosed in the present writ petition about receipt by the petitioner of the order in original dated 16/9/2022, the appeal filed on 10/1/2023 against the same is seen to be within the extended period of limitation prescribed under the proviso to subsection 3A of section 85 of the Finance Act 1994. He submits that erroneously, on account of oversight, the Commissioner of Appeals may have overlooked. The oversight may have ignored the provisions of the proviso to subsection 3A of section 85 of the Act of 1994 and proceeded to dismiss the appeal. So he submits that an error being apparent on the face of the order dated 20/12/2023, the same may mandate an interference from this court. So, however, a delay admittedly having occasioned in the matter in instituting the appeal filed by the appellant herein within the period of 2 months as provided under the provisions of subsection 3A of section 85 of the Finance Act 1994, the further period of 1 month so permitted being only permissible to be so extended on a satisfaction drawn by the Commissioner Appeals in the matter be remanded back to the Commissioner Appeals for a fresh consideration of the issue and to pass fresh orders in the matter. So, I've heard the learned counsel for the parties and perused the materials available on record. The facts noticed herein above are not in dispute. The petitioner contends that the order in original passed on 16/9/2022 was in fact served upon him only on 14/10/2022. Also,
Lordship, regarding the facts, my lord, since we do not, we have not received instructions, my lord. She may observe, my lord, he has the petitioner is at liberty to state everything before the commissioner, my lord, once again, my lord, afresh.
we will
Lord.
open up this thing. We'll
Lord.
open up this thing.
Lord.
Just hear the order.
My lord, observe.
On 14/10/2022. Also, the appeal against the said order in original, order-in-original, dated 16/9/2022 was admittedly instituted by the petitioner hearing on 10/1/2023 before the jurisdictional commissioner appeals, along with the pre-deposit mandated and an application praying for condonation of the delay occasioning in the matter. So, the provisions of section 85 provisions of subsection 3A of section 85 being of relevance, the same is extracted here in below. How many to Maribi? 85. 6 now, again. DB. Also, a perusal of the provisions of section 85, subsection 3A of section 85, mandates that an appeal against an order in original mandates that an appeal against an order of a adjudicating authority, made on or after the Finance Bill, 2012, had received the assent of the President when it relates to service tax, interest or penalty under Chapter 5.
Lord.
Chapter 5 of the said Act of 1994, the same would be permissible to be so presented within 2 months from the date of receipt of such decision of the adjudicating authority. Also, accordingly, the period of limitation as mandated under section 3A or 3A, subsection 3A of section 85 of the Act of 1994 for preferring an appeal is 2 months from the date of receipt of the decision of the adjudicating or order of the adjudicating authority. Also, the appellant in the present petition, admittedly, the petitioner herein had admitted, instituted the connected appeal, the appeal before the before the Commissioner appeals against the order in original dated 16/9/2022 beyond the period of 2 months as mandated under the provisions of section 3A of subsection 3A of section 85 of the Act of 1994. Also, however, what is to be noticed is that a proviso has been incorporated to the provisions of subsection 3 and the same mandates that the Commissioner of Appeals, if satisfied that the appellant was prevented by sufficient cause from presenting the appeal within the period of 2 months as mandated under section 3A, subsection 3A, may be permitted may be allowed to present the appeal within a further extended period of 1 month. Considering the proviso to subsection 3A, this court finds that the appeal instituted in the matter by the petitioner hearing on 10/1/2023 was within the extended period of limitation in terms of the proviso to subsection 3A of section 85 of the Act of 1990. So, having noticed the said position, on a perusal of the conclusions drawn in this on perusal of the conclusions drawn by the Commissioner appeals with regard to the prayer of the petitioner for condonation of the delay occasioning in instituting the connected appeal before it, this court finds that the Commissioner appeal had only taken into consideration the provisions of subsection 3A of section 85 of the Finance Act 1994, but had ignored the provisions of the proviso which had mandated an extension of 1 month subject to satisfaction of the reasons. Subject to the Commissioner appeal drawing satisfaction from the reasons assigned by the appellant that he was prevented by sufficient cause from instituting the appeal within the period of 2 months as provided for in the provisions of subsection 3A. So, the non-consideration by the Commissioner appeals of the provisions of the proviso, said proviso, in the considered view of this court, has rendered has resulted in a relevant consideration not being taken note of by the Commissioner appeals while disposing of the prayer for condonation of delay preferred by the application for condonation of delay preferred by the petitioner herein. Also, in view of the above conclusions drawn by this court, this court is of the considered view that the order dated 20/12/2023 in view or 23 would not be sustainable, and accordingly the same stands set aside. Having interfered with the order dated 20/12/2023, the appeal along with the application for condonation of delay filed therealong by the petitioner stands restored to files before the Commissioner appeals. Also, the Commissioner of Appeals shall now proceed to consider the application for condonation of delay filed by the petitioner along with the appeal as preferred by him against the order in original dated 16/9/2022, on 10/1/2023, and dispose of the said condonation application by reckoning the provisions of the proviso to subsection 3A of section 85 of the Finance Act 1994. the petitioner be granted and due opportunity of hearing before passing of the passing of any final orders with regard to the application for condonation of delay as instituted by him along with the connected appeal preferred before the commissioner bracket appeals in the matter. The petitioner is at further liberty. Petitioner is granted further liberty to bring on record further material that would have a bearing on the consideration of his plea for condonation of his plea for condonation of delay occasioning in the matter, and for justifying that he was so prevented from preferring the appeal within the period of 2 months as provided under the provisions of subsection 3A to section 85 of the Finance Act 1994. 1990. To place before the I'll correct sufficient.
Only thing that the commissioner has already observed that there are no cogent reasons for the condonation.
No, that we have interfered.
No, your lordship, he has already
The
observed.
commissioner of appeals, I'll put it in.
Only below that
The commissioner of appeals, while considering the application for condonation of delay, shall not take into consideration the observations already made in the order dated 2012-2023, which has been interfered by this court
and may, my lord,
today.
and may take into consideration the various judgment of the court that liberal approach.
What লিখিত হৈ দিবচোন appellant কথাটো কৈছো নহয়, along with placing of relevant decisions of the various of the courts of law, competent courts of law, having a bearing on the issue. I'll correct it.
My lord.
Lordship,
Dispose of.
Lordship may further observe them. Your lordship has not any comments regarding
this court. It is further clarified that this court has not made any comments either on the merit of the appeal preferred before the Commissioner Appeals and or with regard to the prayer of the petitioner for condonation of delay occasioning in instituting such appeal. The same would now be mandated to be considered by the Commissioner Appeals afresh after providing due opportunity of hearing to the parties to the proceeding to place their respective cases. I'll correct it.
My lord.
Lordship, always.
No time frame is required. Let them do it. Wait.
Let them appear, lordship, it will be disposed of.
After Behoo's Mr. Sarafil Singh.
I'm obviously.
Yes. Yes, Mr. Gogoi, anything?
Affidavit has been filed.
Affidavit file.
I'm not denying it, my lord.
Huh? Not denying. There were some similar orders passed by me.
The lordship will, my lord, record the contention made in para 5. They say that, my lord, it should be treated as no cause. The DRC one. That's there in the para 5. Last line. Only thing that liberty should be there, my lord, so that we can issue.
Similar order.
Only distinction is there, my lord. This order which I have relied, my lord, is under section 73 and now it is under section 74. Provision is same, my lord. Requirement is same.
Requirement is.
We'll get it on Monday.
Much better.
Dispose of.
Instruction, sir.
Yes.
FIR has been registered.
Not registered, it is a preliminary investigation.
So complicated.
No complicated lawsuit. In the meantime, during the statute period of time prescribed by the statute, petitioner playing a smart game lawsuit. This before the honorable court lawsuit. No coercive action should be taken on 16th lawsuit. FIR was complaint was filed on 8th lawsuit.
You registered the FIR. And
before-
if it is, Mr. Bugay, just a doubt.
Lawsuit.
You registered the FIR. The consequences of law would follow.
Lawsuit. No, otherwise, there is a, my lord may kindly pay us lordship's order on 16th lawsuit. Last paragraph lawsuit. Considering the facts and circumstances, balance of equities, till the next date, no coercive action should be taken lawsuit. As per the statutory prescription prescribed by the statute under 173 lawsuit, 14 days time period is there for preliminary investigation lawsuit. After 14 days preliminary investigation period, we register the case lawsuit. After that, 35 notice have to go lawsuit. In this case, before the 14 days is completed, he has approached before this honorable court lawsuit. Here lawsuit, the complainant should come before this court for not registering of the FIR lawsuit, not the petitioner lawsuit.
Okay, Mr. Chaudhary,
May I come in, my lord?
you
Because
have
I
to come in.
My lord,
You have to come in.
yes, fine. I file an additional affidavit.
Why do you think I'll not allow you to come in?
Because my lord, he has said that I am playing smart game, my lord. Your lordship kindly come to the,
Mr. Chaudhary, English is a language which
Yes,
can
ma'am.
be spoken and understood
yes, my lord.
Various ways.
in with different intentions. He may have used that word only to emphasize
Yes, my lord.
that the matter is getting delayed. You can take a plea that you are that submission of his, you can draw an inference that it is that he's trying to tell you
Yes, my lord.
that you are trying to, by instituting this proceeding,
Yes, my lord.
delay the inevitable.
Yes, my lord.
Either way, the
1 minute, my lord. I know the game is going on in the Busista police station, my lord. Because first, a news item was published.
we got it. We have
Yes,
read
my
it.
lord.
We have
And
read it.
what is the case?
That
Money,
Hindi
there
paper
are
news item.
transaction
We have read
between two person.
Now
that
tell
was
me
not-
one thing.
Now police is searching the petitioner in connection with this without section 35 notice, my lord.
Hmm.
Police come, my lord. In earlier report, whether they are produced before the court or not, they have said, I am avoiding the investigation. So, but without giving 35, how can they say? Earlier instruction they may produce before the court. Then, my lord, after passing the order, I know very well, this type of submission will come. I am going to the commissioner of police. And this letter has been given to the commissioner of police. Let's kindly go through this, my lord. Important thing, my lord. Because I go to get this up. This, you know, kindly go through this. Every time I go to the commissioner of police, that let me know what is the case is registered against me. Because the game is that moment your lordship dispose this matter, my lord, immediately they arrest this person because that person who filed the FIR, he is a very, my lord, high-handedness person in the society, my lord. And today I find it
The
very
proper forum lawsuit? Is it the proper forum lawsuit?
yes, my lord.
Is it the proper forum lawsuit?
Mr. Chaudhary, please have your seat.
Yes,
Mr.
Lordship.
Gogoi,
Lordship,
a preliminary investigation.
lordship, lordship,
You can have a preliminary investigation.
lordship, lordship,
In that preliminary investigation, you have to draw up materials.
lordship.
It is not requisite that you have to draw the statement of the accused also.
Lordship,
Telling you.
lordship, lordship.
Why is the requirement? The accused may not be there. So the
That's why,
preliminary
lordship,
investigation,
that's why,
you have
lordship,
got materials.
that's why after 14 days, we have to register the case. Yes, because honorable court's order is there. Lordship may vacate the
No.
order. Today itself, I will,
No, we are
lordship.
not on that.
Lordship.
Coercive action is qua the petitioner.
Then,
It has got nothing to do
Lordship.
with your investigation and registration.
lordship,
That will be followed by the provisions of the act,
lordship,
new
lordship.
act,
Lordship.
BNS or BNS, whatever. it is.
173.
Three. So what we do is,
Lordship,
we will now close this petition,
lordship, lordship,
saying that
lordship,
till a case is registered,
lordship,
the interim directions passed in the matter
lordship, lordship.
will-
No issue, no issue.
will continue.
Lord-
After the case is registered, that
No
will
issue.
not be.
We'll by the
reviewed. That-
procedure
then
prescribed by the
course of
statute.
law will follow.
Lordship, we'll do.
No, my
We'll do lordship.
lord.
Today itself, lordship.
Lordship, kindly bear with 1 minute, my lord. What they are playing game, my lord, that is, I want to submit. They say that they are waiting to vacate the interim order. Moment interim order is vacated, FIR shall be registered. May I coming, my lord? FIR shall be registered. I may be immediately arrested in this case. Yesterday, I appeared before the IO officer in charge also, my lord. Yes, my lord. And without notice, I am appearing all these things. I know. Your lordship, vacate the interim order, case has been registered and people
No,
will
we
be
can-
arrested.
We cannot.
Mr. Gogoi.
We cannot.
Mr. Gogoi.
Lordship.
Mr. Gogoi,
Lordship.
please, we'll ask you
Lordship.
when it is required.
That is, I go to the commissioner of police also, my lord.
No, PNS.
173, Lordship. 173 procedure is there and 35,
14 days order
35
perfect.
is there, Lordship.
I have 2
Lord-
ears,
Lord-
but I
Lord-
can't hear 2 sounds.
So sorry, my lord.
Lord.
Mr. Chaudhary,
Yes, my lord.
there is a time limit prescribed for a preliminary
That-
investigation
That has been over long back.
long back. Because of the coercive action, that order here,
Yes.
they may not have registered an FIR.
Not said all these things. Your lordship, kindly-
Mr.
Yes, sir.
This, I told you, English language is understood in
Yes, sir.
different manners.
Yes,
So we clarify that.
Yes, my lord.
We will say
Yes.
that the instructions have been placed, that the preliminary investigation is over,
Yes, my lord.
but they could not take your statements. That's why
Sir.
the delay was occasioning.
Yes, my lord.
We'll say that in connection with the preliminary inquiry,
Yes,
the
sir.
statement of the accused is not a material thing.
Yes, my lord.
If you have material, proceed to register the FIR or reject it.
Yes, my lord.
Till the FIR is registered,
Yes, my lord.
they will not take any coercive action against you. Thereafter, the provisions of the BNS will follow.
Lordship.
My submission is something different, my lord.
I can, because Mr. Here, I
Yes,
can
sir.
adjudicate whether the
Yes, my lord.
FIR
Yes, my lord.
instituted
I want to,
is proper or not.
I want to submit one judgment of the apex court, my lord. Due to this type of game in Namibia, lordship, kindly read 11.
It is BNNS.
BNS.
Yes, my lord.
BNS.
14 days time shall be given for the preliminary. That has been over long back.
You have a book?
Lordship.
And
Yes, where do I get it?
11.4, 11.7. If an FIR is not uploaded, needless to say, it shall not be ensured per se, count to obtain benefit of under section 438 CRPC, my lord. They can hold the FIR, my lord, for 24 hours. I have to take from the, my lord, prosecution inspector office, my lord.
You have said you have gone to the prosecution inspector's office, you have gone to the CJM, you have not found
Sir.
a. Actually, it's not registered. Why should it
Yes,
be?
sir.
After registration, within 24 hours, it has to be placed there.
Lordship.
Yes, my lord.
That's the law.
Yes, my lord.
173, Lordship. Then, Lordship, the vertical flag, Lordship, 35.
Fourteen days period has been over long back. It was-
Because that within that 14 days, you were before us
Yes, my
and
lord.
we passed orders
Yes,
in
my
your
lord,
support.
because police is searching the petitioner in connection with this case without giving section 35 notice, my lord. That is the crux of the issue, my lord. Why necessary, my lord, without giving
Okay,
notice?
you want a 35 notice.
Yes, my lord.
Okay.
Yes,
I'll provide.
yes, my lord. That is why I'm submitting.
Mr. Gogoi, this interim order
Lord.
passed on 16/3, I'm clarifying.
Lordship, may
That if
clarify
there
it.
is no, that if you have completed your preliminary
Lordship,
investigation,
Lordship, Lordship,
we'll hold that
Lordship.
because of the orders passed by this court,
Lordship,
you have not taken the matter forward.
Lordship, Lordship,
We will ask you now
Lordship,
that go ahead,
Lordship,
the order will not come in a way
Lordship,
for concluding the preliminary investigation.
Lordship,
And if materials to register a case,
Lordship.
and thereafter, if you want,
Then
issue notice under
As
that.
per procedure
Yes, ma'am.
by the state.
Yes, my lord.
This is the case, Lordship.
I'll clarify
agree,
that.
my lord.
I'm disposing it of. Don't
Beyond that, we cannot also, Lordship.
Yes, my lord. Because, my lord,
What
it is
more is
below the 7 earlier instruction. They have given
Mr.
copy.
Chaudhary,
Yes, my lord.
what I say is
Yes, my lord.
that I'll record their submission,
Yes.
which is there in the instruction,
Yes.
that the preliminary investigation was
Yes, my
done.
lord.
They want you
Yes, my lord.
in the, I'll say you can't.
Yes, my lord.
Second, they say because of the interim order, this is not done. I
Yes, sir.
say the interim order did not restrain you
Yes, my lord.
from taking the matter forward.
Yes, my lord.
You can now proceed with the
Yes, my
matter,
lord.
and if materials are there,
Yes, my lord.
register the FIR.
Yes, my lord.
But before arresting the petitioner, provisions of law as mandated
Yes.
will have to be followed.
It should be done, Lordship, as per
Yes,
law.
but
Later
I
on,
was telling you
case
things
for
on-
Ernest Kumar, we cannot violate, Lordship, Ernest Kumar
ma'am.
provision, Lordship.
Yes, my lord.
So it is 35.
35,
ma'am.
Ernest Kumar, Lordship. It should be, Lordship.
Leha, heard Mr. NNB Chaudhary, learned counsel for the petitioner. Also heard Mr. K. Gugul, learned standing counsel, learned additional senior government advocate appearing for the state respondents. DNSS, what is it? The petitioner in the present writ petition has raised a grievance with regard to the action on the police on action on the part of the police of Bosista police station in harassing him without first registration of a case in pursuance to a first information report lodged in the matter. Where is that FIR?
Yes, my lord. Lordship, kindly come to the case. Page, my lord, 14.
Then?
Page, my lord. FIR, there is no FIR.
No, no FIR, but the
Sorry.
reference
But
Lord's-
reference was page 22, my lord.
22.
Yes, my lord.
And instructions itself, Lordship, reflected on 80, Lordship.
In
Instructions.
pursuance to an FIR lodged on 8/3/2026 by one Harpreet Singh, President of Northeast Transport Association, leveling allegations against the petitioner hearing. So, the petitioner in the present petition has projected that without a registration of the said FIR, which was confirmed by him by taking information from the court of the Chief Judicial Magistrate, as well as from the court of the prosecution inspector attached to the establishment of the Chief Judicial Magistrate Kamrup Metro. So, the petitioner in view of such apprehension of being subjected to undue harassment by the police in pursuance to the lodging of the said FIR on 8/3/2026 had instituted the present writ petition. So, this court, on noticing the projections made by the petitioner in the matter, proceeded while order dated 16/3/2026 to direct that till the next date of listing, no coercive action be taken against the petitioner, including his detention by the Bosista police station. This said order was subsequently aforesaid. Thereafter, while an order dated 19/3/2026, complete instructions not being placed before this court by the respondents, this court had directed that till the next date fixed, the petitioner be not arrested, and the court would pass appropriate orders after registration of a formal ejahar, ipso done. Mr. K. Gogoi, learned counsel, additional senior government advocate appearing for the respondents, has placed on record the instructions received by him from the inspector, from the officer in charge, Bosista police station, dated 27/3/2026. This court has perused the said instructions, contentions made in the said instructions, and finds that on receipt of the FIR dated FIR going to be 8/3/2026, the matter was entrusted to SI bracketed P Vikas Kaman for carrying out a preliminary investigation in the matter, and necessary permission for the same was obtained from the Assistant Commissioner of Police, Posisto. It is further projected that during the preliminary inquiry, the informant as well as the other relevant witnesses were examined. However, although several attempts were made to record the statement of the petitioner, the same was not possible as the petitioner had not appeared before the officer conducting the preliminary inquiry. It is also projected that the police had visited the business premises of the petitioner. However, he was not found present therein. The instructions further proceed to highlight that the matter is still under preliminary inquiry and no formal case has been registered so far. Accordingly, it is projected therein that the necessity of issuance of a notice under Section 35 of the Bharatiya Nya Sanhita BNS had not been reached. Stage for issuance of a notice under Section 35 of the BNS has not been reached. Also, this court has perused this court on perusal of the set of the projections made in the instructions dated 23/3/2026, received by Mr. K. Gugoi, learned additional senior government advocate, finds that the police had carried out a preliminary inquiry. However, the stage at which the same is pending is not disclosed. The only disclosure is that the petitioner had not appeared before the police in connection with the said preliminary inquiry. This court is of the considered view that the non-appearance of the petitioner.
Before that, my lord, I filed an additional, kindly go through it, my lord. Today I filed an additional affidavit. I appeared before the, my lord, Commissioner of Police, also the police station, my lord. But no notice has been made. This is important, my lord. Otherwise, my lord, I appear before the, my lord, Commissioner of Police. The lord say kindly go to affidavit. Today I filed. And earlier also I go to the Commissioner of Police as police station, my lord. That may be recorded.
The appearance of the accused may not be of great relevance, and the investigating authority, in the event during the course of the preliminary inquiry, finds sufficient materials had come on record justifying the allegations leveled in an FIR received, the investigating agency would be at liberty to register a case against, register the FIR, and thereafter proceed against the accused strictly in accordance with the provisions of Section 35 of the PNSS 2023. Also, Mr. NNB Chaudhary, learned counsel for the petitioner, by referring to, just give a note for this, that additional affidavit. By referring to an additional affidavit filed in the matter, has submitted that he had visited the Basista police station to meet the officer in charge on 26/3/2026 and was directed to meet the investigating officer of the matter. The petitioner projects that he had subsequently contacted the investigating officer over phone to inform him that due to current duty engagements, contacted meet the investigating officer. It is further projected that the investigating officer had over telephone informed the petitioner that due to current duty engagements, he was not in a position to meet the petitioner and would meet him subsequently.
Yes, my lord. Also visit the commissioner of police.
The petitioner also projects in the said additional affidavit that he had also approached the Commissioner of Police, Gauhati, and had submitted a representation on 23/3/2026 with regard to the issue raised in the present petition. Also, having noticed the contentions raised by the learned counsel for the parties and also on perusal of the instructions brought on record by Mr. K. Gugoi, learned additional senior government advocate, this court is of the considered view that the provisions of section 140, 173(3) mandates under circumstances set out therein, a preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in the matter. Such preliminary inquiry is to be carried out within a period of 14 days from the date of receipt of the FIR. Also, in the present case, the FIR was lodged on 18/8/3/2026. The period of 14 days as mandated is already over. However, as projected in the instructions furnished before this court, as well as from the submissions of Mr. K. Gugoi, an additional senior government advocate, the respondent authority, the police had not proceeded in the matter on two counts. A, the petitioner's presence was not, the statement of the petitioner was not recorded, and also the directions passed by this court requiring that no coercive action be taken against the petition, including the aspect of arresting him in connection with the same. Also, the above being the position, this court is of the considered view that the present petition can be disposed of with the following directions. 1. A preliminary inquiry having already been initiated in the matter by the police on receipt of the FIR dated 18/8/3/2026, the said preliminary inquiry is required to be taken to its logical conclusion. Also, the police, in the event, in course of the said preliminary inquiry, finds that materials have come on record towards establishing a prima facie case for proceeding in the matter in terms of the FIR dated 8/3/2026, the police is at liberty to register the said FIR, and proceed for a proper investigation in the matter. Also, in the event, basing on the materials coming on record during the preliminary investigation, it not being permissible to ascertain the veracity of the allegations leveled therein against the petitioner, the police is also at liberty to not register the said FIR and close the matter. Also, in the event the police is of the considered view that the FIR would mandate to be registered, basing on the materials coming on record in the preliminary inquiry, the police shall without further delay register the said FIR and proceed for inquiry for further investigation as mandated in the matter. Also, in the event the presence of the petitioner is so required in connection with the investigation of the matter, the police shall ensure his presence only after complying with the provisions of
35.
Section 35 of the Bharatiya Nagrik Suraksha Samhita in the light and also by complying with the directions passed by the Supreme Court of India in this connection. That everybody knows in this connection. Also, it is clarified that till the registration of the FIR, no coercive action shall be permissible to be taken against the petitioner. However, once the FIR is so registered, the police would be at liberty to proceed against the petitioner. However, subject to the compliance of the provisions of Section 35 and the directions passed in this connection by the Honorable Supreme Court. Also, the instructions received by Mr. So-and-so, with the above observations and directions, the present writ petition stands disposed of. The instructions furnished by Mr. K. Gogoi is kept on record and marked as X for the purpose of identification. Done?
Yes, sir.
This was what I was trying to pass on.
I want that law should be followed. Not that, my lord, police is the supreme authority.
Nobody is supreme.
Honorable court is
No, but
supreme
no.
authority.
Honorable court is also subject to
sir.
law.
That's why preliminary instruction in the new
And
accuracy.
I
That's
should
why.
not say all these things because video, my lord. What happened police station, I know very well, my lord. Because I have doing the NSA cases and other cases.
You're a master.
Those days are
No.
gone, Lordship. Those days are gone.
Not done, my lord.
Either way, you are master.
Those
Yes,
days
sir.
are gone.
This side also, this side also.
Lordship.
You know, my
You
lord.
understood?
That's why I'm saying that Lordship, smart game is playing, Lordship. Oblige,
Who
Lordship.
plays?
Mr. Gogoi.
Lordship, just
Why are you instigating Mr. Chaudhary? He's otherwise instigated. Why are you further instigating, creating problems for this court? Cool down. Yes,
Oblige, Lordship.
yes.
Lordship, the instruction is awaited, Lordship. The instruction has to be come from the CEO, Morigaon. Lordship, they are fully occupied with the election-related duties, so it be possible to.
This small instruction he can't give.
Lordship,
Huh? Do you want the instructions to be furnished?
what time maybe, Lordship? After
What is his duty in the elections?
Lordship, they have assigned, they have annexed their second page.
A communication has been placed on record received by Ms. Thapa from the Chief Executive Officer, Jilla Parishad, praying for further time for placing the requisite instructions, for furnishing to her the requisite instructions in terms of the queries raised by this court-wide order dated 23/2026 on the ground that the officials requisite to furnish the instructions are presently engaged in assembly election duty. Ms. Thapa submits that the instructions requisite for answering the queries raised by this court-wide said order dated 23/2026 would be placed before this court on 24/4/2026. Also, no further time shall be granted for the purpose. Registry to list this matter again on 24/4/2026. I'm not fit. You should resign. You being a member, you can't control. And what is the point in being a member of a panchayat?
Lordship, being elected member.
Being elected member, you don't have any power. You are a constitutionally protected person.
Yes, yes.
We'll see.
If the resolution passed.
We'll see. Don't worry.
Lordship, oblige, Lordship.
Yes, Mr. Prokhasto, what do you want?
My lord, in this case, my lord, I have challenged the order of the board.
Board.
And
And if I set aside the order, what would be the effect?
effect, my lord, Lordship kindly see.
No, Mr.
Yes,
Purkastha,
I'm saying.
I'm very kacha in this. That's why I want a
I'm answering you.
clarification.
No, of course, civil court, has the jurisdiction to look into all the aspects of the matter. But
This is with regard to some land.
right. The question is, my lord, there is a direction given by this court in earlier petition to decide the appeal on merit.
Merit.
They didn't decide the matter on merit. Simply on the
Now, Mr. Purkastha,
my lord,
what would be the decision on merit by the board be? What would be the decision?
decision should have been, my lord, that the order which was passed ex parte by the additional deputy commissioner, that has to be, my lord, set aside. Because
What is the order passed by the additional deputy commissioner?
order passed with the, my lord, additional deputy commissioner granting mutation in favor of the private respondent number
Private
6.
respondent.
And that's ex parte.
So ex parte.
Ex parte.
So today we interfere with this order
My
of
lord.
the Board of Revenue.
My lord.
Matter will go back to the Board of
Board
Revenue.
of Revenue.
Board of Revenue will have to now decide
My lord.
whether the mutation is correct or not.
Right.
Or that it has to decide whether the sale deed
My lord.
was duly executed.
My lord.
Right?
That is subject matter of the civil code.
That's
Therefore,
what
my
I'm
lord,
saying.
once your title is under dispute, my lord, my title is under dispute, what is the occasion for the, my lord?
Now, how do you deal with page 128, the bold portion?
My lord. Board portion says, my lord, since civil suit is pending, so I am not
This is
going
an
to
order by
interfere.
the injunction by the civil suit,
Yes,
civil
but-
court. Now, when this is there,
Regarding-
the revenue and authority is
No, no.
hands off.
Status order in respect of possession. I have been in possession.
You
Possession not delivered to me.
continue to be in possession.
I am in possession.
You be in possession.
Therefore, my lord, the mutation which is granted in favor of
I'm
the
sorry,
respondent 6.
because that is the issue which is now pending consideration before the learned civil court.
My lord, right, my lord. But my lord, question I raised, my lord, other days also, my lord, whether during the pendency of a suit, revenue court does have any jurisdiction to interfere with the matter.
We can give you 2-3 judgments
My lord.
wherein the Supreme Court has said
My lord.
that the revenue court will have no jurisdiction.
Revenue court doesn't have to, my lord, and interfere with the title. Revenue court has the jurisdiction to decide the matter of mutation, revenue
See,
matter.
this issue is also the issue of possession is also one of the issues in the before the learned trial court.
So I am just, my lord, my lord, therefore one thing, I raised a question, my lord, in the Google. And Google
Yes,
has given
Mr.
the
Bachcharji, what do you say? Oh, you have raised the question before the Google.
yes,
Very good.
in search. And my lord, with reference to certain decision, it arrived, my lord, it is concluded that
Have you cross-checked that decisions with the Supreme Court decisions in SSC,
Supreme Court says, my lord, mutation-
SKPL, all are bogus decisions
lord,
nowadays in there.
Supreme Court says, my lord, mutation doesn't confine in title.
I'm
Question
sorry,
raised, my lord.
mister, I'm not on that. I am only on the question when the subject matter of the proceedings before the board is a subject matter before the civil court, both is hands off. If not, show me.
My lord, subject matter
I
of the,
understand very less.
but subject matter of the board is in respect of revenue matter, not the title. And revenue court is supposed to deal with the revenue matter.
Okay, we have heard you. Yes, Mr.
My lord, paragraph 3 of the judgment of the Assam Board of Revenue, it is said that while the proceeding was before ADC, Latmondal's report was called for, which confirms possession in favor of respondent number 5.
That we are not.
And
going to.
paragraph 4 is clear, that is the finding. That the sale deed in favor of respondent number 5
That
was
was at
first
first
in
in point of time, his sale deed.
Therefore, the vendor
subsequent.
does not have the right to go for another sale deed.
He is already given up his rights while executing the sale deed in favor of the respondent, Satyanarayan.
So till the matter is adjudicated by the civil court, the revenue, the mutation
Cannot.
order will stand.
And Mr. Professor, when the matter was considered by this court on the last occasion, in the last round of litigation, this issue was never the issue of the civil court. Where is that order of this court?
At page 112.
This is of 2018.
Right.
Now in 21, you had instituted a civil suit. Not you, the other one.
Respondent of file suit.
Fine. And the injunction was passed in 22. Gone.
My lord. Then
Yes, what do you say about this?
My lord,
Whether
lordship-
it is maintained?
Regarding the fraud and all that, he should have gone on to the court challenging this order.
This is not maintainable.
Lordship, can you then make an observation that whatever, my lord, question I raised, that question may be raised before the civil court.
Yeah, how you go? Who is stopping you?
My lord.
Who is stopping you?
Therefore,
You
my-
withdraw it. You withdraw it with that liberty. I'll dismiss it.
Okay. Okay, dividing.
Otherwise, some observation I make
No,
here.
Lordship cannot make any observation.
Ah,
My lord, otherwise it may have some impact on the suit.
that's it. That's why I'm
That's why, my lord,
restraining
Lordship be
myself.
restrained from making an objection.
Because if I
I am
reiterate the contents of the revenue code,
right.
then it will become my order now.
Right, my lord.
Then that will prejudice you there.
Then Lordship may close the matter, giving the liberty.
Mr.
raise-
A.K. Purkhai's learned counsel appearing for the petitioner, after attempting to argue the matter at some length, in view of the order dated 16/12/2022 passed by the Court of the Learned Munsip number 1 Tinsukia in Ms. J case number 35/2021 bracketed N bracket of Lihibako, arising out of title suit number 71/2021 bracketed N, instituted by the respondent number 5 herein, has prayed that he be permitted to withdraw the present petition with liberty to approach the civil court to raise his grievances. Also, prayer is not objected to by Mr. A. Bhakshaji, Learned Standing Counsel, Revenue Counsel, Revenue and Disaster Management Department, and Ms. M. Borman, Learned Government Advocate. Also, in view of the above submissions of the petitioner, the present writ petition stands dismissed with the liberty reserved to the petitioner to approach the approach the learned civil court of the to raise the with the liberty as prayed for.
Lordship, kindly, my lord, instead of allowing me to draw, Lordship may dispose of the matter.
No. Dismiss and I'll have to report reasons.
Lordship may close the matter, my lord.
No, I'll not close. If I close, I'll have to record
Come to
reasons. If you want that, I can do that.
No, that may not
Then it will be prejudicial to you, Mr.
No, that may not be equitable, man.
Dispose. Yes. Mr. Mishra, you say that the income tax authorities, because of that order, which is under appeal.
We don't know reason, my lord. Reason is not there, my lord.
No. You have made a projection
Yes,
that because of that. But the bank has not disclosed that to be the reason. Yes, Mr. You are appealing for?
I'm for the income tax department.
You are not.
Not
Where is the bank?
226(7) of Income Tax Act.
Have you given a letter to the bank in this connection?
No, Lordship, they have not disclosed anything, neither petitioner.
No. You must have that. What is the reason we
Lordship,
want to know?
Allow me some time to I'll obtain
Okay.
instruction.
And Mr. Mishra,
My lord.
you also serve a copy of the writ petition
My lord.
on the branch manager HDFC Bank, respond number 6.
My lord.
Heard Mr. R.S. Mishra, Learned Counsel for the petition. Also heard Mr. S.C. Kal, Learned Standing Counsel, Income Tax Department. Also, the petitioner in the present writ petition has raised a grievance with regard to a debit freeze maintained in his account, maintained with the debit freeze imposed on his account, maintained with the Panbazar branch of the HDFC Bank Limited, that is the respond number 6 herein. Also, issue notice returnable on when?
Can you do it on 21st or
21,
or
22.
My lord.
22/4/2026. Mr. S.C. Kal, Learned Standing Counsel, Income Tax accepts notice on behalf of any CGC.
No, Lordship, respondent number 225.
CGC. K. Gugoi. Mr. K. Gugoi, Upot K. Gugoi likhi diba. K. Gugoi accepts notice on, CGC accepts notice on behalf of respond number 1. Mr. S.C. Kal, Learned Mr. S.C. Kal accepts notice on behalf of respond number 225. So no formal notice. Petitioner to effect service of notice upon respondent number 6 by way of dusty mode. Steps within dusty mode routed through the registry of this court. On effecting such service, petitioner to file an affidavit. Also, on the returnable date, the Mr. Cal as well as the respondent number 6 shall apprise this court as to the reasons behind imposition of a debit freeze with in regard to the account maintained by the petitioner with the respondent number 6 bank. So registry to list this matter again on 22/4/2026.
Look at the interim may consider, my lord.
Huh?
Interim order may
The
consider.
prayer for interim. Issue notice on the prayer for interim. Returnable on 22, so and so, so and so. Instructions to. Same. Yes, Mr. Dhawan. What have you done?
Lordship, I am different lordship against freezing of bank account by Access
no.
Banking lordship. So
The two partners are fighting it out.
yes, your lordship. Two partners are there. So one is not your lordship cooperating, your lordship. 56 lakhs your lordship is in legal.
Respondent number 1. Respondent number 1 by M. Bormon. Huh? A. Dhawan. Huh? Respondent number 1, A. Bormon. Petitioner to take steps for service of notice upon 2, 3, and 4 by speed post as well as by dusty mode. Steps within 3 working days from today. Even the notices are served upon respondent number 2, 3, and 4 by way of dusty mode. Petitioner to file an affidavit in the matter. Also issue notice on the prayer for interim relief. Also returnable on 22. Huh? 22. The respondents to apprise this court with regard to the reason as to why a debit freeze has been imposed upon the account maintained by the petitioner with the respondent number 3.
Yes, your lordship.
3. Respondent number.
Respondent number, your lordship.
3 bank.
3 lordship. Much obliged. Deep obliged, your lordship.
Karbi Anglong land is under the tribal thing. Is there like we have tribal blocks and belts? There is a restriction there also.
Yes.
And from the beginning.
Madam. From 1952 onwards.
Then how can you occupy land there?
No, there is another thing, my lord.
That is the main thing, Mr.
No, the notice is not issued on their account.
Forget it. But when you are occupying land, which is not admittedly not you are not entitled. It's a tribal land per se.
My lord, your lordship can come.
Now the decisions are very clear of the Supreme Court division bench.
Yes, I know.
Your length of period of time is of no use.
That's true. But my
You
lord,
have been removed. No.
my lord, no.
Have you been removed?
No, not yet. There are many.
Show me your right.
My lord,
Show me your right to remain there.
right on the sense, my lord, that I was issued the notice. We were issued the notice, my lord.
That was in 6/2 on 6/2.
6/2. Then, my lord.
15 days time. That is gone. Then
Yes.
the matter was.
Yes.
Then the land was given to some school.
No, that is what the crux of the matter is. Land was given to school when? In 1990. A lots of kind
You were occupying land thereafter. You have raised constructions thereafter.
No, we are from 70 onwards, 75, 78, 79.
Yes, Mr. Chetia, what is your instructions?
First day, my lord, I'll take the instruction, my lord. But
Will you evict them in the meantime?
my lord, latest, but as per the judgment of the Supreme Court also, my lord, and in the similar
Abdul
method,
Kader.
this honorable court also issued the direction in respect of the, my lord, in that area PGR land that issues are there, my lord. So other cases, my learned friend also filed, my lord. Or those cases disposed of with a direction to the petitioner to approach the revenue authority, whether they are right or not, my lord. And till then, my lord, there should not be any eviction. This type of order has already been passed. my lord.
That we can pass. You treat this to be a notice, 6/2 to be a notice. You submit your claim
My lord.
along with the, my Lord Justice Borua's order.
Board's order.
But why and other courts also?
No, no, Mr. Borua's orders will follow. Similar order, my dear. Disposal.
Oblige.
Likhilo person. Ms. Bodley, you're just sitting, just write down the names of all. Mr. Chutia also. Where are my similar orders?
Lord. One, let it be on 8.
Okay.
One.
On the prayer of Mr. B. Gogoi, registered to additional senior government, additional advocate general appearing for the respondents, registered to list this matter again on 6/4/2026.
Lordship.
There are similar orders passed by you.
Lordship, Lordship.
My lord,
Evicted.
yes, my lord.
Afa.
Evicted, my lord.
How
But
long
that
have you been in that?
90 days time
How
was
long have you been in that land?
around 35 years, my lord.
Where were you before 35 years?
My lord, in Borpeta district.
Where have you stated, sir?
No, not stated,
Then-
my lord.
Then,
But my lord, hearing was not conducted.
no, forget the hearing.
Yeah.
Where is your disclosure in this land, in this writ petition, that prior to 35 years, you were staying in X, Y, Z
No,
land
my
in
lord,
Assam?
that is statement is not there, my
You
lord.
might not be in Assam also.
My lord,
How do we draw that presumption?
my lord, that will be, my lord, when the
No, today I have to draw that presumption. I'll have to, because the plea is in the order that you are residents of, you have land in other districts of the state. That's the prescription made here. You have not disputed that.
I'll file an additional affidavit in this regard.
On the prayer of Mr. N. Sarkar, learned counsel for the petitioner, registered to list this matter after 3 weeks on a date to be fixed by it. Mr. Sarkar may bring on record initial affidavit to further justify the contention made that the petitioners are landless people. File an affidavit, we'll see.
Oh, oblige. Where in the case, my lord, a notice can be issued.
How many work orders are there?
There are a lot of work orders. That's
There are
why.
a lot of work orders.
Lot of work orders, completion is done, completion certificate, performance, everything
How
done.
many total work orders?
Total work order, my lord, is in PWD, there are two set. One is legislative assembly, my lord. One is
In this
legislative-
case, there is only legislative assembly or
Yes.
there is something
No,
else?
legislative assembly and PWD, my lord, both. Now, total per amount
It's 17.
is 17 crores 11,49,300.
No, no, all these works were executed in the legislative assembly.
One.
One.
Yes, no. Number of work was executed. And second part, schedule 2 part is PWD.
Where do I get that?
Yes, you
differentiation?
please get it from 270. 270. Let me see 270. Yes, sorry, 218.
280.
It starts from 217. It starts from 270, Office of Executive PWD. Kindly see 217. Don't you got it? 217.
So why have you mixed up the
Yes,
two categories?
No,
of work?
I have. But again, separate
No,
petition.
no, because here the authorities are different.
I know, I understand. Authority, one is legislative assembly and one is the PWD. Definitely, Milo, there are two different authorities. I have made both the one PWD, one.
No, it's
legislative
fine,
assembly,
but
Milo.
the total amount that you are claiming now
Yes.
is not against a particular department.
No,
It's
this
against
is
two departments.
Two departments.
So Why this plurality here we should enter?
My lord, I don't find that it is right, my
Because it's
lord.
not to be released to you from one authority.
No, there has to be release from the both the authorities.
You
Kindly
can,
see
you
the
can
prayer-
take a plea, you can take a plea
Yes.
that both these works were being monitored by PWD. Take that plea, I'll show that.
Kindly see the prayer.
Because PWD is looking after.
I can't see that, my lord. See, 41.
Mr.
Yes, I
Das,
understand what is
Mr.
your-
Das, that these works are not done by Legislative Assembly or the Bodoland.
No, it's the
It's
body-
done by the PWD only.
My lord, what I am saying that this work order, which was given one in listed Assam Legislative Assembly, that separate work order was issued. And so far as PWD, separate work order is being issued.
What are the PWD works?
These are the PWD work.
Page
From 217, my lord.
217.
217, yes.
But then it will be difficult.
Kindly see 218, my lord. 218, 217 was the fund. 1,460 and 111. Lordship got it, my lord. Please see
218.
218.
Hmm.
Notice to proceed with the work.
This is assembly.
Yes. And 218, Lordship got it.
Ah.
Now at page 219
Hmm.
is the completion certificate. Lordship got it.
Okay,
Now-
this is all as Legislative Assembly.
Yes, it's from 217 onward is Legislative Assembly.
No.
Yes.
All Bodoland. No.
Bodoland
no,
also
no.
are under PWD, my lord.
Okay.
Under PWD.
This is Assam Legislative Assembly and
Yes.
Bodoland Legislative Assembly,
Yes.
Territorial Council.
Yes, Territorial Council.
That ends at
That ends, my lord, up to 295. 295. 295.
and where is the work done by for solely for PWD?
My lord, please see at page 222, my lord.
222.
Yes.
All these work orders are issued by the PWD authority.
Yes.
That's what I'm saying.
Right, right.
But Mr. D.K. Das, Learned Counsel for the petition of.
Not here, my lord, as Lordship has stated, my lord. The amount claimed in the prayer is, my lord, in prayer A, it is 11 crore something.
Hmm.
Various work orders issued by, my lord, separate authority. Now, my lord, what
That's
is
the
the amount
problem.
due for a particular work? How, my lord, this honor will go to ascertain, my lord?
I have.
And we'll have to have, my lord, the instructions from various authorities, my lord.
My lord, let him see the writ petition, my lord.
Of
Then
course,
he
I
will
will,
agree.
that's why I'm
He's
referring to
right.
the prayer, my
One
lord.
work is assembly,
We'll have to see the cause of
another
action.
work is Bodoland.
Yes.
Both the authorities are different.
Maybe, my lord, both the authorities are different.
The
I
money will be
understand.
released by Bodoland and by Assam Legislative Assembly. How can you club it?
But my lord, I will explain, my lord, let a notice be issued. I will explain
Notice
to them.
issued means if
I'll
they
explain
submit,
to them. I'll explain to the court, my lord. Why? I'll explain.
you give me an
My
explanation.
lord, that's why I'm saying. But what? So payment from where it will come, my lord? Payment will come from Legislative Assembly only.
Bodoland also.
Yes, Legislative Assembly.
No.
These are Legislative Assembly.
Show me
Kindly
that. Show me
No,
that.
kindly see 223. Kindly see 223. Kindly see 220. For a moment, kindly see 223.
220.
3. Kindly see 223.
Hmm.
Name of the work.
Hmm.
Complete renovation of Bodoland Territorial Council ACM by supplying and erecting the members
Okay.
double unit
Mr.
form deck for
Okay,
the next
got
session.
it. Mr. Buddha, Mr. Gugoi, what is here is that the works are given by your Dispur division,
Lordship.
Capital Construction Division, respond number 9 and 8 are the people.
My lord.
All the work orders, that's what I was asking Mr. Das from the very word go. But Mr. D.K. Das, Learned Senior Counsel, assisted by Mr. Idas. Oh. And Didas and Miss Didas, Learned Counsel for the petitioners. Brief is heavy, so 2 would be required. Also heard Mr. P. Gugoi,
Appear for all.
Learned Additional Advocate General, appearing for all the respondents. The petitioner in the present petition has raised a grievance with regard to non-disbursal of his admitted of his contractual dues amounting to rupees 17, 11, 49, 300 words of negative against works executed by the petitioner in response to work orders issued in the matter by the respondents number 8 and 9. Right?
Yes.
Work orders by 8 and 9. Also, Mr. Das, first, the petitioner further projects that the completion certificates with regard to each of the work orders issued have been also furnished to the petitioner, and accordingly, the amounts involved are admitted amounts. Also, Mr. B. Gogoi, learned counsel for the respondents, but submits that. Learned additional advocate general appearing for the respondent submits that he be granted 3 weeks time to complete his 4 weeks time.
Yes, it will have to
Election.
come from Vijay's
6 weeks time
Yes.
to complete his instructions and file an affidavit in the matter with regard to the claim made by the petitioner of successful completion of the works involved by him. Also, in view of the above, issue notice returnable 6 weeks. Mr. Gogoi accepts notice on behalf of all the respondents. Also, learned counsel for the petitioner shall furnish, if no formal notices to be issued, requisite extra copies, registry to list this matter immediately after completion of 6 weeks from today. The respondents shall bring on record their stand in the matter by way of filing an affidavit before the next date of listing.
One grievance, not K, DK, his K. This is always your object. Make a mistake.
Everything it happens.
Always make a mistake.
D does.
I don't know. Deeply obliged, sir.
You're still Kumar. That's why you're evergreen Kumar.
Deeply obliged.
Very unfortunate letter.
Unfortunate or not, that we will have to ask your father. What is your status in connection with that divorce petition? In that divorce petition, what is your status? Your wife got alimony. You also got a maintenance. So with that maintenance, what does it project? What is the exact position? Because see, in the divorce petition, you have been given a maintenance. If you were with your father, there was no requirement of giving a maintenance to you in that divorce application petition. Court has given you a maintenance of 20,000 per month. If that be so, that means you seem to be not with your father, because your father is still in a hospital.
That has not
permanently.
That has been not reflected in the order of the
Yes.
my lord principal.
Yes.
My lord, so far the maintenance is
Come to
concerned.
the order, Mr. Sharma, you come to the order.
My lord.
Come to page 28. Second, third paragraph, last line. This gives rise to a doubt. And if your mother, and you have never addressed her as a mother anywhere, be that as it may, you have addressed her by a mother, there may be some heart burning, something is there. Your mother got divorced in 22. This account is there prior to 22 because the POA executed prior to that. So this account transactions are taking place prior to 22.
Yes.
Then why in 26 you have raised this grievance?
My lord, lordship may kindly see the power of attorney given by.
I got it. Power of attorney is there. You have been put in charge of that plot of land. You have been asked to do anything.
Yes.
That means from the date of the power of attorney, you are not getting money.
I'm not getting money, my lord.
22, your mother status as the wife of your husband ceased. As the wife of your father ceased. 22 to 26, what happened? No disclosure.
My lord,
No disclosure. You are not getting money
we are
because
not
he is
getting
withdrawing.
money. We are constantly, my lord,
No, you have not. You have
going to
not.
the
No, you
bank
have not.
authority.
No, you have not. You have gone
And
only.
in fact, my lord,
You have gone only, Mr.
Lordship may kindly
Sharma.
say the age of the petitioner, my lord,
Forget
that
it.
daughter.
Forget it.
Is
Now
a
show
young,
me what your
young
daughter
girl, my
is.
lord.
Your daughter being given a maintenance. That
But-
means she is
but-
also not with him.
No, she is with the father. She is with the father, my lord.
Where is this branch? Bhutnan.
Kalipur Bhutnan.
Oh, near you. Kalipur. Famous. You serve a notice on the authorities.
My lord, in the
And
meantime,
we may also direct the, given the circumstances, let's see what the branch manager says. We may even require the police to visit your father to take a statement.
yes, my lord. That's I want. My lord.
Now, tell
Or your
me,
lordship may.
22 to 26, why there was no grievance? Because the
There was a grievance,
transactions
my
were
lord,
being done by your mother.
The petitioner is constantly, my lord, going to the bank authority, send a person, my lord, officials to
That
the.
is in 26, Mr. Sharma. That is now.
Prior to that, my lord.
No,
Prior
no,
to that.
no, your statements are here.
My statement.
Your statements are there.
My statement is there. Paragraph 6.
You
Yes,
come to
right.
paragraph 6. As such, the father of the petitioner is in a so-and-so was informed and the bank authority so-and-so deputed a staff. This is after the representation. Last 3 years.
Prior to that.
Last 3 years. 26,
Last 3
23.
years.
So 22 onwards, this account is being managed by your mother. What is the arrangement? Your father might have permitted her.
No.
How the phone number
Well,
came in then? She cannot put the number on her own.
He put that number on her own, my lord. That is the difficulty.
Mr. D.K. Sharma.
Lordship may kindly see the phone
Heard
numbers
Mr. D.K.
of the-
Sharma, heard Mr. D.K. Sharma, learned counsel for the petitioner. Considering the issue arising in the present writ petition, Mr. Sharma is directed to effect service of notice of the present writ petition upon the respondents number 1 and 2 by way of dusty mode, routed through the registry of this court. How long will it take you to effect that?
My lord, within a week, my lord.
Upon effecting such service, petitioner to file an affidavit in the matter. Oh, sir. Registry to list this matter again on 6/4/2026. The bank authorities on the next date of listing shall apprise this court with regard to the contentions raised by the petitioner in the present writ petition. Also, further orders as would be mandated shall be so passed by this court upon considering the stand of the respondent number 1 and 2 bank.
My lord, interim order, otherwise, my lord, amount will be deposited on 1st of, my lord.
It is being deposited from 22.
My lord.
1 more month. 1 more month.
Please.
1 more, I'm sorry.
It will not affect anybody, my lord.
We want to know what is the exact picture. I'm sorry.
My lord,
This
this
does not give a good vibe.
Not to allow, my lord, to.
Not to allow.
Allow the, my lord, mother of the petitioner to withdraw the amount, my
Now,
lord.
you have said your mother now only. In the petition, you are using her name only. Let us see what is happening. We'll see. Let us get it. We'll see. We have not issued a notice to respond number 3. We have not. Only 1 and 2. We want it. Let's see.
At least, my lord, not to withdraw.
Mr. Sharma, you have other ways also. You can lodge an FIR before the police. Moment they sent it there, it will automatically stall. You have not taken the recourse to that. I don't know why. We get cases day in and day out, wherein only by way of a reference from the police, bank stops complete transactions.
Lordship,
You are not benefiting from 22 from that account. You are not getting even a penny from there.
Yes, my lord.
Then wait for 1 moment.
Lordship may kindly look for a moment the
Okay.
reply of the bank, my lord.
I've
And then
seen it.
against legal
The
notice.
reply of the bank is that, see, we have a confidentiality with regard to this. The numbers that are there, we
For
cannot
a
give
moment,
to-
my lord, page 39, paragraph 3 of
I've
the
seen it.
legal notice, my lord.
I've seen it.
Saving bank account number so and so stands solely in the
Name
name
of
of so and so. Who is the?
You read further, they say that we cannot give you this confidential information with regard to the branch account holders. They cannot.
My lord,
You may be a daughter, they say that with the power of attorney also, we are not permitting you.
my lord,
So we want to hear them, that's all.
my lord.
If you want a date further, we can give you. No, 3rd is a holiday. 6th is the earliest I can give you. 6th we'll see, mister. We'll see.
Petitioner is my lord, without my lord.
You are not here for the petition.
My lord.
You are not here for
At
the,
least to stop the.
you are not here for
transaction.
your father. You are here for yourself.
No.
And you are getting 20,000 per month as per day.
It was, my lord, but subsequently it has been stopped.
We'll see, Mr. Sharma.
And the divorcee is withdrawing the money
That is a
from
family
her
matter. We'll see.
ex-husband, my lord.
We'll see.
Let them- How can the, my lord, respondent withdraw the money of her ex-husband after getting
that
divorced,
you
my-
ask your father or your mother. They will tell you. The
Same
court is
thing
not in a
cannot-
position to answer.
My lord,
We'll see, Mr. Sharma. Next. We'll see. Don't worry. Doesn't give a good vibe. That's the only thing.
that's true, my lord.
We'll see.
That is why I have said, my lord, it is very unfortunate.
We'll see where it is unfortunate.
My lord, may please call item 16, 17, 18, and 20 for similar matters.
15 is not auspicious.
No, my lord.
I prepared the 15 only, my lord. I thought.
No, 15 only.
All issues are same.
All issues are same.
15 doesn't do.
Now, Mr. Dr. Saraf, all this thing pertains to an issuance of notice under 50. Right? What prejudice is caused?
Right. No, the PMLA Act. Section 3, your lawsuit can see first.
That PMLA Act to move to
India. Whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition, or use, projecting or claiming it uncensored proceeds shall be guilty of the offences of the money laundering. So it must be proceeds of crime. Now the proceeds of crime has been defined. You'll also see clause section 2U. 2U, no?
Mr. Dr. Saraf, this stage in this case has not come. You have been only issued with a notice under 52
Well, I'm submitting the bill.
to give records or documents because you are connected with that man, the person, what is his name? Dhawan.
Well, what I'm submitting for lawsuit that that person, Mr. Dhawan,
Diwan.
that person against whom the connected is.
That's the only saving grace.
I'm submitting.
That there is a no coercive order from this court.
My lord, I'm submitting. Against him also an FIR was registered. And thereafter, the scheduled offense, whatever was there, the cognizance was not taken. It was dropped after discharge. And unless until the scheduled offense under the Act, without the proceedings cannot move. That is a Supreme Court judgment also.
Mr. Dr. Saraf, what we could understand, it's with regard to a proceeding per se. But 52 says that for the purpose of investigation, he can require any person to come to 52.
Well, I just submit. 50 means whether he can call XYZ anybody.
No, he has not called XYZ. He has called you only because of this agreement, deed of partnership.
0.5% I'm the partner.
Be that as it may,
Well,
some connection is already there.
But the question is that the proceedings, it must be connected with the proceedings of crime. And it has to be a scheduled offense. There is no scheduled offense. That's why no coercive measures order was passed in the earlier case.
No, my lord.
Why you are jumping
Mr. Dhar,
Sorry,
do you think I am biased?
No, my lord.
Then I'll hear you also.
He can make
I'll hear you. A senior is making submissions.
I'm sorry.
Let him make it. Yes.
You'll also may see one judgment below. Paragraph 53.
But there are decisions of the other high courts also on this point.
What is the reason, Lord?
Because if they have examined 1550, even Supreme Court, examine 50,
I have no doubt, Lord, Supreme
no,
Court.
examine 50 in the light of 23 of the.
Yes, yes,
Constitution.
I will place that one also. It is not violative of section 23, article 23. I am not on that question at all, my lord. Lordship, see page, para 53. Page 48. Have you also got it, my lord? Very, last two lines.
Okay.
The respondent authority can summon any person to record a statement or produce a document or record only in cases where there is credible evidence that an offense under section 3 of the PMLA Act has been committed, and in such circumstances, the person who has been summoned cannot raise any grievance against the ensuing summons. Thus, in the light of the circumstances of this case, when no prima facie case has been established in showing that an offense has been committed in such PMLA and no incriminating material has been elicited at the time of search and seizure, the issuance of the summons to the petitioner lacks legal authority. The petitioner cannot be compelled to appear and record statements or produce documents such as actions would be justified infringing on the personal right of
So
the.
do you mean to say that for the issuance of a notice under 50, even to a third person who is not there, the person against whom the PMLA proceedings have been instituted must be a proceeding within the schedule, drawing the schedule offense.
My lord.
Now let us see the notice.
Well, I'll just, there in the notice, nothing is mentioned. That is the interesting part. Your lordship, see the notice at page 92. उसका जो petition दे दूँ ना, ये चल रहा है उसके पास में.
Hey, Baba.
अरे अभी कौन सा केस चल रहा है?
ले लो।
15 नंबर चल रहा है. 15 नंबर. हमारा petition दिया ना 15 नंबर. ये मतलब summons.
Now, against whom is the main case of PMLA?
That is the main
instituted?
partner, my lord. Main partner,
Main partner, Devan.
my lord.
And the others who were arrested
My lord.
in connection with that, they have been now acquitted.
There is no arrest.
Earlier, that transportation of liquor.
My lord,
They have been discharged.
They have been
They've been
discharged.
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 That order is there.
And my lord, when the FIR was filed, my lord, the schedule offenses were there, but the offenses, all the sections have been dropped. Now there is no schedule offense.
Against Devan.
Against demand.
No, my lord. They are
So,
Page 86. Sir.
please, you can argue. You can make submissions that
No,
are
no.
better. I am making misleading the court.
Hear you, don't worry.
Maybe, my lord, perhaps I am misleading the court.
Oh, it's nothing.
Proper, my lord.
Mr. Dada,
Page 81 is.
these things happen day in and out. Please don't get perturbed with that.
Well, I am not.
Mr. Dhar,
I am not.
be patient. Your time will come.
Sections.
81.
Well, lordship, see page 81. The type copy, my lord. The various sections, your lordship, see in the first. Against which the FIR was there, my lord. Now thereafter, your lordship, see the order,
Discharged. With page 86.
page 86.
Now, not leaving order. सच्चे दिवस नहीं यार. 86, page 86.
Page 86. Last but one paragraph, my lord.
Only that Excise Act 53(1) was.
The year of the Assam Excise Act. And now this is not a schedule offense.
Based on this, they have filed an CIR 77E.
Now, on the basis of this, 27
E.
Schedule offense under 2Y.
to I will.
Enforcement of case, nature of civil.
Now, lordship, see page 77. ये क्या बोलते हैं इसको ECR? Page 77, my lord. In spite of the fact that the other charges were dropped, you lordship, see nature of the schedule offense. Schedule offense, Indian Penal Code, section 420. 420 is not there. Same police station, same FIR. It is dropped.
420 was there, but subsequently it was
It was dropped. After dropping it, my lord, they filed ECR.
no appeal against this order.
My lord,
No proceeding against this order is not assailed by the prosecution.
so that already assailed in the earlier petition.
No. The prosecution has not assailed this
No,
dropping
no.
of.
No,
After they file OA.
after they filed the original application on the basis of the same,
Section 17,
Section 17.
annex page 41.
So you mean to say that the offense now against in the FIR, it's only, the one is also a party in that FIR?
My name is, his
No,
name is
he's
not
not
there.
there. He's not there. There were only two persons,
My lord.
Das and someone.
Now, whoever is there is no schedule offense.
Now, how is Devan brought in?
The Diwan was also
Due to the
connection, some connection, my lord.
No, whether he is connected in the criminal case also?
Criminal case, FIR, no. His name is not
The
there.
charge sheet?
Charge sheet is not there, no? Charge sheet not there. Discharged on other ground. Now, last time further similar. Karnataka. One more judgment I have to place before loss.
No, judgment will come. Let us have the facts. Whether he is an accused in that
No,
criminal case.
no. Neither Diwan nor the person.
So where is this ECIR
That has
10/2024?
page 70, page 77.
70 point. As well examine. Just 5 sections.
But here, Devan is not there.
My lord, not there.
And it is only on 420.
My lord. You'll also see paragraph page 77B, my lord.
Seven A B.
7.5. Meanwhile, a letter has been received from my Superintendent Excise, Golaghat, Assam, stating that the state of Assam is incurring huge losses due to smuggling of the cheap liquor from the Arunachal Pradesh. Since huge chunk of the revenue of the state exchequer is earned by the Excise Department. And
So it is only on 420 in that demo case that the PMLA proceedings were initiated. Now you say that 420 has been dropped.
And 7.5 you also see at page 77B. Can this be by any region be said to be below the case of the PMLA? Revenue loss to the state because the goods are coming from the state of Arunachal Pradesh, smuggled. Loss of revenue is there. It cannot be. That's why the Excise Act, the violation may be there. That in the FIR, Excise Act has been mentioned.
And you say that that is the reason for the interim order. What happened to this proceedings?
They're pending.
by Devan?
They're pending. And you'll also just for my satisfaction, you'll also kindly see one more judgment. Doto?
They did, yes.
At page number page.
Last.
इसमें क्या है?
उसमें वो someone.
Now, where is this requirement, Mr. Dr. Saraf, in the Act?
My lord.
That only for a schedule offense?
Well, that.
That does show me that.
My lord. Section constitutional offense होना पड़ेगा. PMLA तो है, section 3 में तो है. हाँ, section 3 you'll also see.
Yeah. Provided aware the procedure of crime for the money, any offense, paragraph 2, part.
Section 4 my lord. Proviso.
Just then.
Judgment निकालो ना वो.
And schedule.
Judgment निकालो ना वो उसका main judgment पास में डालो. I think पहले निकालो ना उसी पेज. Page
Section 4.
my lord. So this is judgment of Supreme Court. It starts at page 1, my lord. And also see para 106 at page 164. The proceeds of crime being the core of the ingredients of the constitution, no offense of money laundering. That expression needs to be construed strictly in that all properties recovered or attached by the investigating officer in connection with the criminal activity relating to a schedule offense under general law cannot be regarded as a proceeds of crime. There may be cases where the property involved in the commission of the crime of schedule offense attached by the investigating officer dealing with that offense cannot be wholly or partly regarded as proceeds of crime within the meaning of section so and so of the act. So long as the whole or some portion of the property has been derived or obtained by a person as a result of the criminal activity relating to a schedule offense, a stated schedule offense, to be the proceeds of the crime, therefore, the property must be derived or obtained directly or indirectly as a result of the criminal activity relating to the schedule offense. To put it differently, the vehicle used in commission of the schedule offense may be attached as a property in the case of the criminal crime concern. It may well will not be proceeds of the crime within the meaning of section so and so of the act. Similarly, possession of the unaccounted property required by illegal means may be actionable for tax violations and yet will not be regarded as the proceeds of crime unless the tax legislation concerningly prescribes such violation as an offense and such offense is in a schedule, is included in the schedule to the 2000 Act for being regarded as the proceeds of crime so and so. So any offense under any act must be included in the schedule to be a schedule offense, and unless there is a schedule offense, the PMLA Act will not be applicable.
Yes, Mr. Dhar.
One more before he starts. One judgment you lost may just similar agreement.
Again from Karnataka.
Karnataka. I'm just placing those lawsuit. Last question.
Last question.
Yes.
Bench.
At page
23.
23. Last part note. The coordinate bench holds that for a summon under section 50, which is followed by a search and seizure in the case therein under section 17 of the Act, where no prima facie case has been established showing that an offense has been committed under the Act, or no incriminating material has been restated at the time of search and seizure, issuance of the summon to the petitioner lacks legal authority. The petitioner in the case in hand is on a far better reading. The petitioner was earlier working with so and so. Thereafter, lost 13. If it was someone simpliciter as obtaining under section 51 of the CRPC or so and so, it would have been a circumstance altogether different. A caveat this finding would become applicable in the case. The enforcement action is imparting to someone inquiring to the matter in the incidents that have happened so and so. So, my lord, he must be connected somewhere.
No, that's a different thing altogether. Now, what you are trying to project is, Dr. Saha, one clarification.
My lord.
Say there is no schedule offense. Police case is not registered. But maybe a search is made or a case is registered because of some information. Admittedly, if there is a smuggling, there is money being generated. And that money is now doubted to be laundered. So in this circumstances, dehance the police case, can the authorities do it?
No, that is the judgment of the apex court, that without there being a criminal case registered in respect of the schedule offense, the enforcement directorate cannot
come in.
My lord, come in.
Yes, Mr.
My lord. My lord will come to page number 18 of the writ petition, my lord.
18.
89.
18, and yes.
Here, my lord, that Diwan case, my lord, my senior was referring to. In para 3, my lord will find this is the that issue was particularly where the petitioner challenged the ECIR, my lord.
No, Mr. ECIR means what? What is ECIR?
ECIR, my lord, this is an internal document of the.
That is that page, it's already there.
No, I am coming there, my lord.
Oh.
My lord will grant me some time, my lord.
Yeah.
Yes, my lord. So, my lord, here basically the challenge was to the ECIR. Now, my lord, in this case, we have summoned. Now, the petitioner is aggrieved that we cannot summon. Why? My lord, these cases are still pending. My lord, this is not only one ECIR. We have a ECIR which connects to almost 500 cases. Additional affidavits has been filed there in this case, my lord. So, it's a very big syndicate we are investigating. Now, coming back to my lord, whether can we summon? My lord, a similar case came up before this honorable court, High Court. In that, my lord, CBI, while filing the charge sheet, CBI, while filing the charge sheet, my lord, dropped the name of the accused, that petitioner, my lord. Thereafter, ED came in, my lord. They filed, sent a section 50 summon to the petitioner. He came and challenged this before the honorable court. This is our High Court. Our High Court and my lord allowed the case, set aside the summon. We went to the Supreme Court. Now, my lord, I have placed both our High Court's order and Supreme Court's order. What it is that, my lord, whether can we, please. Our first, my lord, I will just show, my lord, our High Court's order, my lord. My lord, it is a criminal, in a IA criminal.
Give me 2 minutes. Mr. Dhar.
My lord.
Subject to correction.
My lord.
Here, see, the power of the ED to come in the provisions of the PMLA Act
50
is through the criminal case that is registered against a particular individual or a group of individuals. Under certain sections of IPC then,
yes, my lord,
which is stated to be a schedule offense under the, in the schedule, 3 schedules are there. The first schedule relates to IPC offenses in the PMLA Act. Now, if those sections are there, then the power of ED is over prevailing. It can do the necessary investigation. Now, in this case, the schedule offenses were there. it continued to remain in the charge sheet also. But for some reason, the person was discharged. The discharge of the person does not take away the case from the purview of the schedule offences. Now, what is happening here? That's a clarification I want from you. Here, you had registered a case under particular sections of law. But when the matter went up to the charge framing stage, the court did not discharge the accused. What it did was, it said that there is no material under the IPC offences, which 420, which would form a part of the schedule offence. Your ECIR is basically on 420, which is a schedule offence. Now, if that be so, when the 420 has been taken away, where is the schedule offence now being there to proceed in the matter? This is a clarification.
My lord, the ECIR is still alive.
No, because ECIR is qua demo police station. If you can check up the ECIR, ECIR is qua demo police station. Now I want to know, once the court, because that's a very important stage. You may put in 1,000 sections, but what is the material that's for the court to, when the court has examined it and has come to a conclusion that 420, no material, dropped. See, it's not letting the person off. Here the issue was, the person was let off, but the schedule offence against others continued. So here the ED is not concerned with who the accused are. It's only concerned with a schedule offence being there. If a schedule offence is there, the power to investigate is vested with the ED authorities, with you. But if the schedule offence is no longer there, what would be the position? What is the Supreme Court saying on?
My lord, PMLA is a standalone, my lord.
We got it, but standalone to a criminal case. A criminal case, how will you hold it to be existing when the charges have been dropped?
My lord, not only this, there are hundreds of live FIRs are there.
Against?
Yes, my lord, this against the syndicate. They are not only one, my lord. We are investigating the whole.
Okay, fine. That issue is pending before this court in that connected Sanjay Diwan.
Connected. Yes.
Now you see of a situation.
Yes, my lord.
The main accused, this court has protected.
My lord.
These people are drawing through the main accused. There cannot be a direct allegation against them.
Yes.
It is through the main accused only they'll come in. So once the main accused has been protected, why these people will not be protected? Because you don't have, at least till now, any material against them. You are collecting material.
We are collecting materials, my lord.
I got it. So why don't you get this matter thrashed out, WPC 2357, and then proceed in the matter? What is the rush? Anyway, you can't take any action against them without taking an action on Sanjay Devan. Sanjay Devan, you are not in a position to take action because of the interim directions. So we link up all these cases. Affidavits have already been filed in the other matters. Dr. Saraf is appearing. So we fix a date, hear the matter. Till that time, no coercive action.
Only one thing which you also asked me a question.
But my lord, they have to cooperate. In that, my lord,
I will not cooperate. I will
my
not
lord,
go. Why I should go?
My lord, calls
Mr.
Sanjay Diwan case, my lord, court gave a direction to cooperate with the investigation.
Where is that order?
My lord, I'm giving the very fast day, my lord.
In that case, ECR was filed and original application was filed.
No.
My lord.
In the earlier case, please.
Where is that order?
My lord, just I'm taking it from the net, my lord. The very
no,
fast
when there is a no coercive order.
But there was a direction to cooperate.
Okay, that documents, whatever they have, they will furnish, but don't take any action against them.
No, till now we haven't taken any action against them.
No, you will not take further also till the matter is.
But my lord, they have to.
They will cooperate with you. Don't worry about it.
My lord,
we'll provide.
I'm giving the order, my lord. My lord,
and in the application submitted by the petitioners also, there was an observation made that within 1 month they'll give the documents. Mr. Dr. Saraf,
I will submit only once, give me 5 minutes, my lord.
You give that order to.
I'll give, my lord. Your lordship, one, see the judgment, my lord, compilation, my lord. One judgment for my. It starts from page 311, and lordship may kindly see page 320. But the para 13, my lord. Or I may take your lordship directly to page 321, para 15. The conditions precedent for the existence of the procedures of crime is the existence of the schedule offense. On this aspect, so and so. And thereafter, you also may skip over and may come to my lord, para 18, page 323. In a given case, if the prosecution for the schedule offense comes to in the acquittal of all the accused plus discharge of all the accused, the proceedings of the schedule offenses are quashed to the entirety. The schedule offenses will not exist, and therefore no one can be prosecuted in the offense punishable under section 3 of the PMLA Act. Now, once there is no schedule offense at all, where is the question of applicability of the section 3 of the PMLA Act?
Please read further.
My lord.
Thus, the PMLA is filed with benefit from the schedule offense ending by acquittal or discharge of all accused.
My lord.
Similarly, he will get the benefit of quashing the proceedings of the schedule offense. However, an accused in a PMLA case who comes into the picture after the schedule offense is committed by assisting in the concealment or use of proceeds of crime need not be an accused in the schedule offense. See.
My lord.
Such an accused can still be prosecuted under PMLA so long as the schedule offense exists.
Lord, I am saying that if there was no schedule offense, then anybody who assists will also be accused, my lord, for under section 3 of the PMLA Act.
But
now, my lord, by submission only before lordship, my lord, here the summon has been issued to me without saying that in which connection, which offense, or which inquiry you are.
We'll see the summon once more.
My lord, also may see the summon. Page
92.
Page 92.
91.
91 it starts.
Page 91.
My lord.
This is against the same EICR? No.
Nothing is mentioned, my lord, nothing. You'll also see page 92 below. Why am I asked for in connection with which case?
Okay. Mr. Or,
My lord.
as the main accused is protected,
My lord.
for the time being, we'll protect them. But on the next date, when the matter is listed, you renew your prayer for their participation after you file your affidavits.
Documents, whatever they have asked for, we have already given.
You have given.
Now they want me to come personally and appear.
Okay.
That may not be below documents I've given. That is the below the receiving also it is there.
Okay, done. But doctor, all these cases are same orders would be there. Same date of notice.
Same.
Notices are date.
Same.
But Dr. A. Sarab,
And my learned friend was saying that there are 500 cases. At least he should send all, we can file petitions all. Why
assisted
5
by
only?
Mr. S.P. Sharma, learned counsel for the petition. So heard Mr. R. Learned. You are standing counsel, ED.
ED, my lord.
Standing counsel, Enforcement Directorate, appearing for the respondents number 1 and 2. 1 and 2, both?
My lord.
Note kang apna?
Oh, sir.
No note.
One is Union of India, no problem. Ministry of...
No. Union, my lord. My lord. Record, Arket Dev Chaudhary.
Mr. RKD Chaudhary, Deputy SGI for respond number 1. And Mr. Ardhot, Learned Standing Counsel, Enforcement Directorate for respond number.
Only for your convenience, my lord, Your Lordship.
No, we are not going into deep into this.
No, I'm just giving all your.
That is for my consumption.
Page number, lecture, etc.
No, we are not going. The petitioner has instituted the present writ petition assailing a summon dated 60/2/2026 issued by the respondent number 2. All the summons are same, Mr. Sharma. All the summons are 6/2 issued by the respondent number 2, invoking the provisions of Section 50 of the Prevention of Money Laundering Act 2002, requiring the petitioner to give evidence and or produce documents as mentioned in the schedule to the said notice. Also, Dr. Saraf at the outset by referring to the provisions of the Act of 2002 has submitted that the power of the Enforcement Directorate to investigate into a offense so arises in the event a police case is registered and therein the sections so attracted falls within the offenses set out in the schedule to the Act of 2002. Dr. Saraf submits that the initiation of the criminal proceedings in the present matter was with the registration of Demo PS case number
Page 30. Page 30, page 13 of 5/5/2024. So yes, also
Demo PS number 13 of 2024 under section 379, 420/420/34 IPC, read with section 53(1)(a) of the Assam Excise Act. Dr. Saraf submits that the police, on conclusion of the submits that the section 420 having been incorporated in Demo PS case number 13 of 2024, the same being a schedule offense, the ED authorities, the Enforcement Directorate authorities instituted an inquiry in the matter. Dr. Saraf further points out that the police, on conclusion of investigation in Demo PS case number 13 of 2024, had submitted a charge sheet against the accused therein under section 379/420/34, read with section 53(a)(1) of the Assam Excise Act 2010. It is submitted that the trial court, while framing charges against the accused in PRC number 165/2024, on examination of the materials brought on record in the charge sheet, had found that there was no material to form a prima facie opinion with regard to the accused therein committing an offence under section 379/420/34. Accordingly, the said sections accordingly the charges leveled under the said section in the charge sheet came to be dropped. It is further highlighted that the accused therein were charged only under section 53(1)(a) of the Assam Excise Act, read with section 34 of the IPC. Dr. Saraf accordingly submits that there being no scheduled offence presently alleged against the accused in PRC case number 165 of 2024 arising from Demo PS case number 13/2024, the Enforcement Directorate would not have jurisdiction to continue with further investigation in the matter in pursuance to the ECIR registered against Sanjay Devan and Ritu Devan. Also, accordingly, he submits that, Dr. Saraf further submits that a schedule offence not being there, submits that the accused in Demo PS case number 13 of 2024 not being further charged under a schedule offence, under an offence which is a schedule offence in the PMLA Act, the notices issued to the petitioners invoking the provisions of section 50 of the 50(2) of the PMLA Act would not be sustainable. That's your basic submission. Mr. R. Learned Counsel for the petitioner disputes the said position and submits that a police case having been registered in the matter and therein a schedule offence being involved, the provisions of the PMLA Act 2002 would stand automatically attracted, and the subsequent dropping of the said charges, dropping of the charge which is also included as a schedule offence under the Act of 2002 would not deprive the Enforcement Directorate authorities of the jurisdiction to continue to investigate the matter. So, you want to file an affidavit here?
I will file.
Mr. Dhar submits that the stand of the respondent, represented by him, would be brought on record by way of filing an affidavit, and therein the Enforcement Directorate authorities would deal with the submission of the petitioner that on dropping of the schedule offence from the charges involved in PRC case number so-and-so, the Enforcement Directorate does not lose its jurisdiction to continue to investigate the matter on the basis of the case already registered by it in the. The submissions made by the Learned Counsel for the parties have been considered by this. This court is of the considered view that the said submissions would require a detailed consideration, and the same would be permissible only after the respondents have filed an affidavit in the. Accordingly, the respondents are directed to file their affidavit. When is that case fixed now?
Date is not there.
Affidavit on or before. How long will you take, Mr. You give me a date, but file it. That's all.
Yes, my lord. End of April, my lord.
On or before 30/4/2026. On filing of such affidavit, petitioner to file its rejoinder, ipso advised, on or before 10 days will do.
15 days, my lord,
15.
because, yeah, Nachal.
On or before 15/5/2026. Registry to list this matter again on 20/5/2026 in the motion column. Also, considering the submissions raised by by Dr. A. Saraf and considering the submissions raised by Mr. Dr. A. Saraf with regard to the jurisdiction of the Enforcement Directorate authorities to continue to investigate the matter under by invoking the provisions of the Prevention of Money Laundering Act 2002, this court provides that till the next date of listing, the Enforcement Directorate authorities shall not insist for the personal appearance of the petitioner before them. The said direction is also passed by considering the submission made by Dr. Saraf that in pursuance to the notice dated so and so, the documents as sought for therein has already been, all the petitioners are filed.
Yes, all five.
All the petitioners have
All the petitions.
has already been submitted before the concerned authority by the petitioners.
Only one paragraph of that judgment of the apex court will also considers, my lord, that in case it is discharged, then the.
No. We will not do anything. No.
Why purpose is there? No? That is-
You have got your documents. Exempt the man till the next date. Registry to list this matter again on what? Please, 25/2020. Interesting.
All the cases, my lord.
Huh?
All the cases.
22 also.
All,
All 5 cases.
all 5 cases.
15, 16,
No.
17,
15, 16,
15, 16, 17, 18,
22.
22.
22. Mr. Sharma, you can take this back. I'll just, in the afternoon, just go through it. You can take it back in the evening.
We'll give you, get a photocopy for further, my lord. We'll give you.
You
You lost
lost
it, keep it, my lord.
No. I just want to go. I'll just take a note. I can give it back.
My lord.
You can take it in the afternoon.
I'm highly obliged, my lord.
A new thing I have learned today. PMLA. Interesting.
Very interesting, my lord. Very interesting subject.
But Dr. Saraf, all said and done. Yes, who is for the APDCL? APDCL. Yes, Mr. Abhishek.
Lord, my
APDCL name is not.
first submission is this, my lord. We are in the Khash land, my lord. We are in the
Oh.
landless.
The land was taken over for APDCL.
APDCL, my lord.
They are not party,
My lord, they are party,
but their names are not reflected.
my lord. My humble submission before your lordship, we are 50 years in Khash land, my lord. And government by notification in 2022, 11/11/2022, invited application under
That has not been taken to its
Assam
logical conclusion.
taken into consideration. What happened, my lord? These petitions were said to be rejected. Rejection order I have annexed. And they said that the land is reserved for other purpose. But interestingly, my lord, that land is given to APDCL, my lords, later than our petition is rejected. Before,
After your petition.
before rejection of our petition. And they said that it is given. Now, my lord, my humble submission before your lordship,
No, we'll have APDCL also. On
2019 policy, my lord. It is.
You're entitled that
Yes, my lord.
rejection is cryptic.
My lord, cryptic, my lord.
Sharma,
And another thing is
rejection
this,
is
my lord,
cryptic.
no notice was issued. No notice, previous notice
Okay.
was issued.
the grievance, one of the grievances raised in the present petition is that after the rejection of the applications of the petitioners for settlement of the land in question with the petitioners, the same was mutated in the name of APDCL.
Not after rejection, before rejection.
But before rejection, the land settlement, which was rejected. So it is further projected that the land in question was reserved for APDCL authorities. APDCL is made apart is arrayed as respondent number 5 in the present writ petition. However, the name of the standing council APDCL is not reflected in the cause list. Also, petitioner to serve a copy of the writ petition upon the APDCL authorities and registry to list this matter again on 31. To give a copy.
On Monday, my lord.
On 30. No, 30 will be difficult, Mr. Because tomorrow is closed. 31.
31 Monday.
And they're not doing anything, don't worry, because it is election code of conduct is on way. Nothing will happen.
20 days.
31st.
21 Monday.
31.
31. Hello.
Mangalbar. Next Tuesday. You serve, madam, you serve a copy now only. By reflecting the name of APDCL in the cost list.
Obligation.
Reason not assigned.
Reason not assigned.
You serve a copy on the which is that respond number 5.
Excellent. And my reason is that they are not assigned any reason. Only stated I have annexed that the document from the server authority that FIR has been lodged against us.
Where is that?
If you also go to the page 26, annex of 4.
Which is the police station?
Ajra.
Mr. A. Sharma, learned. You can take the instruction. A. Sharma, learned counsel.
It will be better if the PPs, it will be.
Right, you're right. Mr. Sharma shall receive instruction as to why a lien was debit freeze was mandated to be imposed upon the account maintained by the petition with the respondent number 5 branch, 5 bank, respondent number 5 bank. The said instruction be furnished before this court on the next date of listing. Registry to list this matter again on 2nd or 6th. Which one is comfortable?
Let it be 6th, Lord.
6/4/2020.
4 also, 4 and 5. 4 is also Axis Bank.
No, no, Axis Bank, because they only acted on the police thing. Let the police come and say. Yes, Mr. Chaudhary.
Victim of the collateral damage. We are 31 legalized.
This is grazing land.
No, my lord, it was because it was some portion was de-reserved for Anchalik Panchayat, some were for
that for public purpose they can do, but how can they do for you?
My lord, because it was for the Anchalik Panchayat. Now, my lord, they have, when the complaint was made, they said there are 30 legalized bhetis are there. Page 35, your lordship will find it.
You have already been evicted.
My lord, evicted, my lord, but there are bazaar. Another petition is pending, WPC 1243/2026. Let these two matters come together, my lord, your lordship will find it, my lord.
As prayed for by Mr. P.K. Roy Chaudhary, it's motion stage.
No, my lord, notice was issued in there.
I heard Mr. P.K. Roy Chaudhary, learned counsel for the petitioner. Also heard Mr. A. Bhattaji, learned standing counsel. Revenue and Disaster Management Department, and Mr. May you appearing? Mr. N. Das, learned. Oh, upor likha, Ms. P. Thapa, Learned Counsel appearing
One.
for the Panchayat and Rural Development Department,
1 and 6.
Mr. A. Bhattaji, Standing Counsel, Revenue and Disaster Management Department, and Mr. N. Das, Learned Government Advocate. Also. Issue notice returnable on 22/4/2026. Also, Ms. P. Thapa, Learned Counsel, accepts notice on behalf of respondent number 1
6.
and 6. Mr. A. Bhattaji accepts notice on behalf of respondent number 2, while Mr. N. Das accepts notice on behalf of respondent number 3, 4, 5, 3, 4, and 5. The Learned Counsel for the respondents to complete their instructions and apprise this court of their stand on the next date of listing. Registry to list this matter again on 22/4/2026, along with WPC number
1243/2026.
1243/2026.
Obliged.
Mr. Chetia, same matter like Mr.
Well, it is, my lord, earlier, my lord, no, it is not similar, my lord. Earlier, my lord, petitioner approached this court, my lord. Court passed the order to pass a region order after hearing both the parties. And the region order has been passed that the petitioner is trying to occupying the another plot of land. So the speaking order is at, my lord, page 77.
Yes,
And the earlier High Court's order, my lord, is at page 65. And the operative part is page 70, my lord, paragraph 12.
Yes. What is the error in the speaking order, Mr. Ola?
Yes, Lordship. Lordship, our case is that we are in Patta number 10 and Dag number 16. Our land is 21 bigha, more than 21 bigha, Lordship. The annexure 1 and 2 is the Jamabandi as well as the...
How was this land transferred to you in the first place?
Lordship, it is a Miyadi Patta land, Lordship.
No, but it's in the tribal area. How can it be transferred to a non-tribal?
Lordship.
That area,
yes.
that block, our like chapter 10, like regulation is also applicable in that
Lordship,
area.
It can be settled, Lordship. It can be settled.
But it's not settled to you. It was.
We have an act, my lord, Karbi Anglong transfer of land act, my lord. Executive committee permission is required. On the permission only it can be transferred. Otherwise,
Lordship, there are many legal points, Lordship. One legal point is that, Lordship, I am having Miyadi Patta, having landholding certificates, having possession with this brick kin and all other
When was this land transferred to you?
Yes, Lordship, the annexure page 26 and 27. Page 26 and 27, it is, Lordship. 26 is landholding certificate, Lordship. 27 is Jamabandi, Lordship.
No, when did you come into possession of this land?
2011, Lordship. 2010-11. From 2000. Yes.
Before that?
Lordship, before that, it was this not Miyadi land, Lordship. It was possessed by.
But where is the permission? That is the main issue. Where is the permission?
Lordship, here in this case, Lordship.
You might have got the land somehow. That's a different thing. That you will be compensated or something that we will see. But what is your right to hold this land in a tribal area? You are admittedly
one pertinent question, Lordship. It is as on date, it is Miyadi Patta land, and this Patta has not been cancelled by the respondent authority. And the alleged respondent number 8 from Timu, that they have said that the settlement is made to them, and that is also Miyadi Patta land.
Come to page 79.
Yes, Lordship.
They say that both the lands are different.
Lordship, that is the
Mr. Chiriya, have you got your
78, my lord, second paragraph, it is clear, my lord. The petitioner is occupying a different land and he is starting to construct in another plot of land, my lord. So that is specific finding is there. Now the
What is
demarcation
your
to take.
contention with regard to this finding in your petition?
Lordship, yes, Lordship. My contention is that, Lordship.
Para?
Para 10, Lordship. Then thereafter also, but para 10, Lordship. They are trying to grab my land, Lordship, under the garb of that this dark number 66 and 133.
Mr. D. Ulla, Learned Counsel for the petitioner. Also heard Mr.
And Miadi Patal, and they cannot evict, Lordship, unless and until it is cancelled.
Heard Mr. N. Bodoloi, Learned Standing Counsel, Revenue and Disaster Management Department. Who is for respond number 2? Also heard Mr. Hills Area Department, Mr. Sharma, you let me. Also heard Mr. Adhar, Learned Standing Counsel, Hills Area Department, and Mr. J. Chiriya, Learned Standing Counsel, Karbi and Autonomous Council. Issue notice returnable. Returnable. When can you complete your instructions?
Yeah, after view vacation.
Returnable on 22 4 2026. Also, Ms. N. Bodole accepts notice on behalf of respond number 1. Mr. Adhar accepts notice on behalf of respond number 2. While Mr. J. Chutiya accepts notice on behalf of respond number
356.
7.
7, my lord, 4 and 7.
5 Uport H. Sharma will likhi bade. Government, additional senior government. Mr. H. Sharma accepts notice on behalf of respond number 4 and 7. No formal notice is to be issued. However, request Pabina. So, petitioner to take steps for service of notice upon the respond number 8 by way of registered post with AD. The petitioner in the present writ petition has projected that the patta land of the petitioner is being now sought to be a petition in the present writ petition has projected that the petitioners in the present writ petition has projected that they are now being sought to be evicted from their patta land. It is submitted that although a finding has been recorded in the speaking order dated 12/3/2026 that the land from wherein the petitioners are now being sought to be evicted is not a patta land claimed by the petitioner, but a us land, but a different land.
Yes.
Covered by DAG number 168, patta number 66, measuring 2 biga 4 kata 19 lesa, while the petitioner claims that he is possessing land by patta under patta number 10, DAG number 16. Also, it is submitted that the said 2 plots of land are totally different, and accordingly, the apprehension of the petitioner that he is being sought to be evicted from his patta land is clearly unsustainable. Also, considering the said projection made in the writ petition, it is directed that the petitioners having projected that they are possessing land over DAG number, patta number 16.
Patta number 10, DAG number 16.
Our patta under patta number 10 over DAG number 16. It is directed that till the next returnable date, the petitioners be not evicted from the land. Petitioners, all the petitioners.
Lordship,
only one petitioner.
Yes, Lordship.
Petitioners be not evicted from the land possessed by them under patta number 10,
Dark number 16, my lord.
Pusa.
Without following due procedure of law.
Pusa. In the event the land possessed by the petitioners are required for a public purpose, are required by the government, the petitioners be evicted therefrom only by following the due procedure of law.
Lordship, one more submission. Lordship, tomorrow,
We have said that they will not touch patta number 10, dark number 16.
Only my submission is that learned counsel shall inform the this respondent concerned because of the fact that
much you can do.
Yes, Lord.
I'll try to upload the order.
Yes,
I'll try to upload the order today.
Only. That. Oblige, sir.
I've not said anything. I've said only don't touch
My
the
lord.
patta line.
My lord. And my lord, for before eviction or cancellation of patta is required to be done under Rule 26 also. Then it can be. Otherwise,
wherever if he is, that is his patta land.
My lord.
If that is identified, you cannot. But is it a cadastral that?
My lord, no, my lord. That is main problem is that it is not cadastral land. So, my lord, before cancellation of his patta, it is required to be given an opportunity of hearing. Then patta is required to be cancelled. Then he can be evicted. That is as per the act.
High Court judgment is also
The only problem is that there the cadastral maps are not there.
In each and every village, my lord.
Anyway, don't touch his.
My lord, my lord.
No, oblige.
May I please, Lordship, my lord, on last occasion, my junior heard the matter, my lord. Now, my lord.
Yes.
On last occasion, the order passed with the direction to produce the file, Lordship. File concerning SN number 102. Lordship. On last occasion, my lord, there is an order.
Lordship, this particular brief came to me only yesterday evening, Lordship, and I received the record today morning.
What is the record?
Lordship, first thing, Lordship, I don't know why this matter is pending since 2015, Lordship. Because of the fact that the impugn letter at page 66.
That is issued by the finance.
Has no connection with the petitioner. Lordship, may kindly see that, Lordship, page 66. It is not at all connected with the petitioner to be aggrieved with, Lordship. Page 66, Annexure 8. Lordship, may kindly read. Finance Department have no objection to enhance remuneration to 59 numbers of engaged persons as at flag E, serial number 1 to 59, as per Finance Department number so and so. Further, Finance Department observed that list submitted by flag E, same flag E, is for 64 persons, of which serial number 60 to 64, that is 5 new names are included in the list, which are not found in the original list as concurred earlier by endorsement dated 10/2/2011. So the original list is 10/2/2011. At page 50N of the file number so and so. The department is therefore directed to conduct a detailed inquiry. We are not connected with this portion. So Lordship will first query should be whether your name is included in the list, original list dated 10/2/2011.
That he admits.
Not there.
We are not saying.
Fine.
If it is not there,
please have a seat.
If it is not there, Lordship.
Please have a seat, Mr. Bhuya. The submission of Mr. Bhuya is, if you can come to that list, which is there at Annexure 6.
Yes. It is not there.
Need not be.
If it is not there, Lordship, this
not there,
particular
let's
decision
forget
should have been challenged.
Now, therein 72 people are there.
Yes.
Now, what he says is, persons at 53 to 59, that's the case.
Lordship.
Their names are also not there in the first list. Why they are now being given?
Their names are there. Some of the names are there, but that is not the issue. That is not the issue.
That
should not be the issue. Lordship, if Lordship peruses the record, Lordship will clearly hold that should not be the issue, because that was a list approved for one particular year only. For 1 year. And now we are in 2026, Lordship.
What is the status of these people? Are they getting the higher wages now?
They are not even working today, Lordship.
They're not
These petitioners are not even working. And those 72 who were given approval on daily wage basis for that particular event, even most of them are not working.
You are not working as on date.
Not working.
Not
From
presently,
when?
my lord, but at the time of filing the
From
petition.
when? From when?
But when the, that is not formally not released, Lord.
What? Formally not.
Formally not released.
We are not, never formally engaged.
And Lordship.
Lordship may kindly see serial number 1, Lordship. Lordship may kindly see page 21. He is petitioner number 1.
Page?
21. Page 21. Here this is Pranabjyoti Borua has been performing his duty as daily wage cleaning workers secretariat since 2008. This is not an appointment letter. If Lordship comes to the next page, Lordship, this is the security pass. This is valid up to.
So everybody will have to have it.
No, till since Lordship will see the date till when it was valid. It was valid till 5/11/2013. Lordship may kindly see the second petitioner, Lordship, at page 37. Page 37. He is the second petitioner. Working since 2013. And next page, Lordship, his security pass. It was valid up to 26/1/2015.
But there is a engagement in 2014 also.
No, this is 14. Lordship will see the security passes till when they are allowed to enter the capital complex, Lordship. Serial number 3, Lordship, page 44. Daily wage worker.
The serial number, the Ashwini Barpus Besburua, he is found to be working till 15.
Yes, all of them were working till 15, Lordship.
After that, they are not there.
No.
Can you make that statement?
Yes, Lordship, I'm making, Lordship. That is the official, although it is not in the affidavit. Affidavit at night.
Affidavit, it's not.
Affidavit, it's not there, Lordship. But they are not working.
Yes, what do you say?
Lordship will kindly see the record, Lordship. One document is important. Lordship will say page 15 and 16, Lordship only.
Why these facts were not placed before this court? Every day adjournments were being
Yes,
taken.
Lordship. Probably this case was not properly dealt with, Lordship.
Because you, Mr. Fukan, came in only in the fag end of this matter.
Yes, Lordship.
Last, what one
Names
day.
are not shown.
Names are also not.
Not shown.
Page 15 and?
Page 15, flagged, Lordship. In page 15, Lordship, Lordship will see the bottom portion. Lordship may kindly see this was endorsed on 19/1/2011 to the Finance Department for
just page 15.
15, Lordship, 15.
15.
I think it is flagged, Lordship.
That's an orange flag.
No, at the top, flag is at the top.
Orange flag.
The relevant portion is at the bottom.
Orange flag, the first one.
The note sheet.
Lordship, yeah, Lordship may kindly see the previous page, Lordship, page 15. Bottom portion, Lordship. Finance EC3 Department. Secretary's approval above may be seen. The information sought for by your endorsement at page 39 has been given at page 13 and 14 with proper justification. Finance EC3 Department is requested for their concurrence to create the 120 numbers of grade 4 posts in daily wage basis. Next page is the approval, Lordship will see. Names forwarded is 120. And names approved, Lordship.
Where are you saying?
16, page 16.
16, huh? 16, it says Finance Department, your note dated 10/2/2011.
Yes, 10/2. This is 10/2. Finance Department have no objection for engaging persons as shown in A, list of daily wage laborers.
So A is page 17.
Previous one list was forwarded, 120 list.
That list is there at page 17.
Yes, 120 list is there.
No, not 120.
No.
72.
72, I mean concurred. This letter, this letter.
Concurrence list is here.
Yes.
That is
Lordship,
the list at page annexure 6.
yes, 72 list is there. Lordship, may kindly see that endorsement, Lordship, concurrence by the Finance Department. Finance Department has no objection for engaging persons as shown in A of least daily wages labor, annexure 1, as below on daily wage basis as in the previous years. So this list comes every year. Lordship will see total number is 72. Next line is important. This is, however, subject to condition that they shall have no right to claim regular appointment as above. That will be, I mean, even
How
not even
was the
question.
list wherein the petitioner's name figure?
Petitioner's name not figure.
No. Subsequently, how was that list prepared?
72. Lordship, a list of 120 was forwarded to the Finance Department. Finance Department gave approval in respect
Come
of
to
72.
23, and what is 23?
And while preparing this final list of 72, Lordship, a serial was concerned. Suppose first one is cleaner. I'm giving an example. Suppose 30 names were forwarded. They calculated from that list, Lordship, and given approval to the first 10 or 15, Lordship. That was the procedure followed, Lordship. So 2-3 things are very important, Lordship. That list was for 1 year only, first thing. And in that list itself, their names were not there. Subsequently, it was decided to enhance the fixed pay of 59 employees from that list. So if his name is not there in the original list itself, Lordship, there is no question of giving enhancement to him, Lordship. So the the letter by which they are aggrieved, Lordship, I don't see any reason why they should be aggrieved.
Give me 2 minutes. Sir, please have your seat. What is that note dated? Impugned note dated? Impugned.
Impugned, my lord, here, my lord, 66 page is number 66.
Date.
Date 15/12/2014. 15/12/2014. The
15/12?
15/12/2014.
14.
Lord, may I submit one thing, my lord?
Just. In the 120 list also, their names are not there.
120, they were not there. 120, they were not there. In the 72 also not, they were not there. So there is no question of having their name in the impugn notice, impugn order lordship, impugn letter.
No. Impugn letter, it's covering them. Impugn letter is covering them because it is they who have been now doubted.
No, this impugn letter has connection with the lease dated 10 to 2011, page 66 of the writ petition. Second paragraph, lordship. Original list are not found in the original list dated so and so.
No, that is these two lists, Mr.
So
the
this
first one is you come to page, this is there in your records also, 61.
So this
Come to 61, come to 61.
61. The original list.
Yes, this is the 72.
72 list.
That has been
now
approved by the
come
finance.
to 64.
64 to sir?
64.
Think it did. Think it was the speed.
Here petitioner name appear from serial number 60 to 64. Regarding place of posting.
The whether lordship, this is 72.
No, this is 69.
No, this is list of 72. So far as 60 page
64, 64, page 64.
Okay.
It's a list of 64.
Lordship.
Where is that in your this file? Mr. Pukan, where do I get that endorsements with regard to this in this file?
Lordship, the Lordship says checks the second orange, my lord, second orange, but not the first, second one. That is the list, my lord.
No, that is 72.
120 list, my lord. From there, 72 they have marked it.
No, this is not 120.
120.
Lordship,
No.
these
What
list-
I'm saying
Lord-
is page annexus 7.
Lordship will only see the chronology. Lordship, this is a list, Lordship, just prior to that 2014 finance endorsement.
That's what it
Yes.
went to the finance, but I'm not getting it.
That is why finance said in this 64, 59 should have been there.
I got it, but where is that material here?
That in the note sheet, Lordship, it is clear there. Note states, Lordship, this is 64. Finance Department observed that list submitted by flag E is for 64 persons, of which serial number 60 to 64, that is 5 new names are included in the list, which are not found in the original list of 2011. So it is the objection of the finance also that they should not have been, their names should not have been
That
there.
is exactly the position.
Yes.
But where do I get it here?
One flag E should be there, Lords.
31/11/2014 is the endorsement by which this was sent.
Yes.
Where do I get that 31/11/2014?
At page
The-
30N, I think. 30N. That is a different file, Lordship. Your endorsement and dated 31.
That is the file that was required.
Yes, that is in file number SN 48 of 2012. That is a different file, Lordship.
So this list wherein the petitioner's name figure was sent white file number 48 of 2012.
No. Petitioner's name did not figure in the list of 120.
I'm not on that. I'm on page 64. Where is the list?
Lordship, page 64 has the original in the list at page 61.
I got it, Mr.
Lordship.
I got it. But the SAD authority sent this to the finance department.
Yes.
Where is that sending? Where is the note preceding that? This note dated 31/11/2014, basing on which?
In file number 48 of 2012.
That is one which we require.
Create a file to disseminate. No, Lordship, that file we are not having, Lordship. What the-
This file was asked for.
Oh, that we made a mistake.
Yes, SN 10205 PT. Lordship, see the last one.
102, that is a mistake.
10205 PT.
We got it. That is one main file, but you should also have brought this file. 38 of 2000, because this endorsement is made there. This endorsement dated 31/11/2014 from the SAD is made in file number 48 of 2012. Where is that file?
And that also has to be called.
You get that record.
But even then, the facts will remain, Lordship.
No, but
in
we want to
2011
know,
also
we
there
want to know what is the basis for including the names of the petitioners. What? That much only. What you said is correct.
Lordship will appreciate. Finance department already taken note of that fact, that this list should have contained 59 names. You have entered 60 to 64 in addition.
Okay, fine. Now we can dismiss it, but that grievance of his will remain. We'll close it once and for all. Mr. A. Fukun, Learned Counsel for the petitioner, has produced the file number
40
S bracketed N 102/2005 PT. However, to appreciate the contention of the finance department as contained in the impugned note dated 15/12/2014, this court would be required to peruse file number S bracketed N 48.48/2012. Mr. Fukun, to produce the said file on when?
Next week.
Next week.
On 2/4/2026. Mr. Bhuya.
Otherwise, my lord.
And get me the date from when they are not.
File.
Along with the date.
Also,
Mr. Fukun shall also apprise this court the period for which the petitioners herein were so engaged.
Lordship, that date could be little difficult from the petition, Lordship. Till the month they were receiving salary,
difficult?
they work till that day.
No, the salaries that have been disbursed is being disbursed
15 months salary.
Yes,
has been-
till 15 they
15
receive
months
salary.
by way account transfer.
After that, there is nothing.
Nothing, Lordship.
Okay, no like it.
That is in the petition itself.
Till, my lord,
They've given the bank
December
statement.
2014, salary has been disbursed from my.
Salary is given till?
2015, Lordship.
December 2014.
December 2015.
And till filing of the writ petition, where was also in service.
After that, you know.
There are no.
When did you file?
no formal-
25/3.
Formal termination, no formal termination. And my lord, one thing may I submit, so far file is concerned 120 to 102. Here, my lord, page 65, I have clearly noted against vacancy. When 5 persons were regularized, then against the vacancy, we are.
I got it.
Adjusted. That is the. So how
Because
how
some
can say
persons
mystic?
were, some persons were in that from that list. Regularized, not regularized, selected and appointed against the grade 4 post.
Get for post.
Okay, we'll see.
Lord, just giving one example, so far as petitioner number 3 is concerned, he received salary up to 7/1/2015, January.
All salary.
The problem is the case was filed in March.
15.
So after March, that statement will not be there.
So their bank statement, they're
That
still
bank
having the
statement
bank
will be
statement.
till March only. After March, how will they bring?
No, it was still January, Lordship. They are showing that.
Oh,
January.
they filed this case in March. So
Yes.
at least till March that will be there. After March, how will it be there?
At least the February statements would have been there.
And Lordship, there is an order
They can,
7/10/2015.
even now they can place that statement, Lordship.
7/10/2015, there is an order. Regarding the file.
Learned counsel for the petitioner shall on the next date of listing apprise this court as to the date till which the petitioners have received their respective salaries. This will be required if I have to allow it.
I have enclosed all salaries slip.
Beyond this, you are not received.
There I have already been enclosed, my lord.
Mr. Bria, beyond this, you have not received. Mr. Bria, learned counsel for the petitioner at this stage has submitted that the petitioners have received salary till the month of December 2014 and in a few cases till this January 2015.
Obliged.
Yes, Mr. Chaudhary, have you got the instructions?
Lordship, we have tried, but thing is due to the elections, Lordship.
Oh, are we also in election?
No. They have to get it, the corrected position from the civil authorities. The Army DEO has visited the DC office, but there is no work.
Mr. Your name?
T. Kashyap,
K. Kashyap, learned counsel for the petition. Also heard Mr. R.K.D. Chaudhary on the DYSG appearing for the response. Appearing for the response number 1 and 2. Mr. Chaudhary has submitted that in terms of the order directions passed by this court the order dated 19/3/2026. The instructions, the particulars required to be so received for apprising this court with regard to the dark numbers of the land possessed by the petitioner and the change therein occasioning over the period of, and the change in the dark number occasioning over the period of time, was not permissible inasmuch as the revenue authorities on account of the ensuing assembly elections are not in a position to disclose this information. Accordingly, he prays that the matter be taken up. Give me a date.
The last week of April, Lordship.
On 30 or 30?
That's fine, Lordship.
On 30. Accordingly, he prays that the matter be taken up on 30/4/2026, on which date he shall place the requisite information before this court. Accordingly, registry to list this matter again on 30/4/2026. Interim order passed earlier to continue till the next day.
Much obliged.
I think we should also take a holiday till 9th because nothing is happening.
In fact, things are like if somebody is not in the election process, they are also busy. They are also busy.
Now that day I got somebody asking, he's in the election process. I said, how come the man, what is he doing in the election? Yes.
May please, Lordship. On the last order, last charge was given to the respondent to file affidavit, Lordship. I think not file affidavit. This is the NGO, Lordship. They are the halfway home, Lordship. This is a grievance, Lordship. 2 financial years, Lordship. Amount was not paid, Lordship. This, Lordship. 2021 and 21-22. Before that and after that also release, Lordship. This is the grievance, Lordship.
Where is your engagement order?
Agreement, Lordship, page number 27, Lordship, agreement, Lordship. Sign on 26/11/2014, Lordship. Even agreement, Lordship.
Yes, who is appearing? Agreement is with the government of Assam.
That is the social
Who
department.
is appearing? Where is Mr. Das? Aram Das. Get hold of Mr. Aram Das. Standing counsel. Standing counsel, this, what do you call that, social justice or something?
Yes, boss.
Get him. His name is not shown. Item given it to?
29 lakhs.
Social
Social
justice and
Justice Department
empowerment.
from.
Get him, others will take, we will do what is required to be done.
Yes.
Get him.
May it please the Lordship.
Yes, Mr. Doctor, after a long time.
Lordship, the issue pertains to Lordship wrongfully occupying my land, private patta land by the irrigation department.
Why are you doing
Lordship,
that?
we have filed our affidavit, and my friend also had today filed their affidavit, Lordship, reply, my friend.
File a reply.
Yes, I have filed my reply.
I have
today.
that have to be in the records, Lordship.
Alan, may
Oh, we'll
Our
have to not
stand is,
presume.
Lordship,
We'll have to presume that the land was voluntarily donated.
donated, Lordship.
It was not voluntarily donated.
Lordship, our stand is that, Lordship.
How can it be? Where is the document? Have you mutated your name
Lordship,
in the, have you mutated the name in your land records that it is?
That was perhaps not done. That was
Then-
perhaps not done.
then-
But the land was, Lordship, donated in the year 1987, Lordship.
Maybe by 1987, even prior to that maybe.
Lordship.
But there is no instrument.
yes, ma'am.
Lordship, I fix the matter for hearing, Lordship.
No, today only. What is more to be heard? This much only.
My reply is also on that. Lordship.
Lordship, I will take the instruction that there are any records of.
You have taken instruction and filed the
No,
affidavit.
we have filed our
Then
affidavit.
that-
There may be some records of Lordship
No.
to donate.
Well, that should have come here.
Lordship. I will.
That should have come here.
Statement is there, Lordship.
Statement is not there. Statement is probably.
No. Lordship may kindly see paragraph
It
7.
is evident from the continued possession will not give that assumption to be drawn. Yes, Mr. Das.
Page 38, my lord.
38, huh?
Paragraph 4, my lord.
Hmm.
Below. Be it stated that the land in which the structure has been constructed was already in possession of the irrigation department from the year 1987, in which canal system now exists and no new well has been
Yes,
taken.
why this matter was not agitated before?
My lord, the
My lord.
issue is, my lord,
One more statement. The land is presently in the name of Sorumai Hirani, wife of Soyaram and 11 others, Patadar, as record available in the office.
You have filed an affidavit.
my lord, it
Okay.
was,
The learned counsel for the petitioner has submitted that rejoinder affidavit has been filed to the affidavit filed by the respondent number 2. What about respondent number 6?
my lord, that will also file, my lord.
You file.
No, my lord, tomorrow I will file it, my lord.
Then why are you pressing the matter? Mr. Doctor submits that an affidavit in reply to the affidavit filed by the respondent number 6 would also be brought on record by 6/4/2026. Registered to list this matter again on 4/5/2026.
Obliged.
For admissions.
4-5.
Obliged, Lordship.
May I submit, my lord, very outset, my lord, I have filed an affidavit in reply today, my lord. The against the respondents have an affidavit, my lord. And we have brought certain facts, my lord. Let this affidavit come on record, my lord. Today I have filed, my lord. I have served.
On the prayer of Mr. B. Borwa, learned counsel for the petitioner submits that an affidavit in reply to the affidavit filed by the respondent number 7 has been filed today. Accordingly, he prays that the present petition be taken up along with the said affidavit in reply.
1st of April.
Registered to list the present petition along with the affidavit in reply filed by the petitioner on
1st of April, can it, my lord? Because they are doing the construction, therefore I have to place your lordship.
24/4/2026.
Earlier interim order.
Interim order to continue till the next date of it.
25.
Yes, Mr. Nandi.
Lordship. Lordship, I got instructions, some instructions from bank. These are the instructions.
No, forget it. What is, why the land is not being handed over?
No, Lordship, just I'm praising. In this, so far the land is concerned, symbolic possession was taken with the bank. Thereafter, he participated in the auction. His bid was accepted. And thereafter, we have filed application before the district magistrate for physical possession. Now, district magistrate has given order for physical possession, and I've submitted before your lordships twice. We have also submitted police cost.
But this land, you have not been able to make it free from encroachment.
No, not free from encroachment. In the meantime, what happened, lordship? They have filed a civil suit.
Who?
The sister of the respondent number 4.
Okay.
Before year.
That means the land in the near future cannot be handed over.
In the civil court.
Okay, Mr. What fault is this? You offered, he bought.
I agree,
right?
Lord. I'm not disputing.
So now we reverse the surfacing. We put him in the shoes of the bank and you in the shoes of a borrower. Now you quote your interest. How much you want? They'll pay. This is not done.
Lordship. In fact, Lordship, the notice itself, it was stated, the physical possession of which has been taken by the authority.
I've seen it.
That is,
You have misled him, Mr. Nandi.
that is symbolic position.
No.
No,
Why? Mr. Nandi, when you projected it, it said physical possession. We have gone through it. Now, tell me the interest that we'll have to quote. And it will be compound interest now. How bank charges, you will have to pay.
I'll take instruction, lordship. On that, I will take instruction.
No instruction required. So
On
Nandi
that,
is enough.
I'll take instruction. Let it come on money.
You give the land within a week or pay him the complete amount with 18% compound interest.
That I have to take instruction because of my own I cannot.
Sir, I'll pass you. Why a citizen is to be made suffer after you projecting, he comes. And now you are satisfied, your loan is satisfied, your records you have cleared up.
No.
Your roads, where is the money otherwise?
The money, that is the thing, lordship. The money has not been credited in the loan account, which is in the form of demand draft lying with the bank. We have not credited in the loan account.
With you and in the loan account, it's the same
It's
thing.
not credited. We can give an affidavit.
Money he's losing. When did you make that payment?
Lordship, almost 2 years back, Lordship.
2 years. And 2 years he's losing that you in your account that you have put it in your suspense account maybe. And that is now calculated
3
in
years,
your budget, in your that profit and loss statement
So
also.
we have made a demand draft and it is kept separately.
That
in the-
demand draft, you make it only against money. You don't make it without money.
No.
So that money is in circulation in your bank.
What is in my instructions? I
Oh,
can-
no. Mr. Nandi is more than that. Mr. Nandi is State Bank of India. We know.
No.
So that money is in circulation. You are giving it for loan. And this poor man, he is suffering.
What happened? What I
When will you complete your instructions? 7/4.
As your lordship pleases. And I'll be
Right.
submitting affidavit,
Also,
lordship. Well, because
the submission made by Mr. Nandi, learned counsel for the petition, reveals that from the submissions made by Mr. Nandi, it is clear that the land in question would not be permissible to be handed over to the petitioner in the near future. Also, accordingly, Mr. Kapil had prayed that the amount deposited by him as the sale price for the land be returned to him along with interest at bank norms, more particularly the interest that the petition bank would charge under such circumstances against a loan advanced by them. Mr. Nandi submits that he would complete his instructions and apprise this court of the matter on 7/4/2026.
obliged.
Now, this is the second case. One, somehow I could not pass. This I am passing.
As your lordship pleases.
And if there is a legal bar, let me know. Yes, Mr. Chaudhary, what are you waiting for?
My lord, here,
After this.
but for urgent medical treatment, the petitioner sold a plot of land, my lord, and for that, my lord, petitioner has applied for sale permission.
Give me 2 minutes.
My lord.
It's an eviction matter. Yes.
Petitioner has applied for sale permission to sell a plot of land, my lord. Petitioner is the absolute purchaser. But the sale permission has not been granted by the concerned circle officer and the district commissioner, my lord, only on the ground that the purchaser.
You have a notification now. Has it been sent to the government? Revenue Department by the Deputy Commissioner. There is a latest notification. SOP has been laid down.
Yes.
What happened? Why
Now,
do you
the
have it?
Deputy Commissioner has to.
Has it done? Who is for the Deputy Commissioner?
H. Sharma appears.
Has it been done? Yes, there is a notification nowadays. SOP.
In the religion.
That they will now process it and send it to the nodal officer.
36.
Mr. N. Das, learned government advocate, shall apprise this court on the next date of listing as to whether the jurisdictional deputy commissioner, the jurisdictional district commissioner, district commissioner, co-district commissioner, has on processing of the matter, does not rejected, I suppose,
No update, my lord, as of now.
has forwarded the application of the petitioner for sale of land, for issuance of no objection certificate for sale of land to the nodal officer in the Revenue and Disaster Management Department. In terms of the SOP formulated wide notification dated
9/9/2025.
9/9/2025.
My lord, let the name of H. Sharma be shown in my.
Registered to list this matter again.
No. Yeah, in the order first.
Registered to list this matter again on election 27, on 27/4/2026, reflecting the name of Mr. H. Sharma, additional.
Not in the cause list, my lord, in the order today, in the place of N. Das.
Oh, N. Das report H. Sharma likhi de.
This was allotted.
That's all right.
All right.
Please, Your Lordship. There is an application for implement, but
Registered to list this matter, I can't appear. I appeared for advice.
I was instructed by once.
Registered to list this matter before any other bench without me.
Can a date be fixed?
Huh?
Can a date be fixed?
Huh?
Can a date be fixed?
I'm not entitled to take up this matter. How can I pass on order other than this? Yes, Mr. Ahmed.
My lord, for mutation, my lord.
After vacation. No issue. They will not be. On the prayer of the Land Council for the parties registered to list this matter again on 29/4/2026.
Obliged.
Thus, complete your instructions.
Here, please, Lordship. Lordship, in this case, one of our senior counsel mentioned this case for listing, my lord, and inadvertently he wrote in the stage of the case, my lord, motion stage wrote, and the honorable lordship imposed a fine of cost of rupees 5,000, lordship. Mr. R.I. Bhuya, he is very young counsel, lordship. He do.
You go before the same court.
Lord.
This order, the present interlocutory application has been instituted. Praying for a modification of the order dated 16/9/2025, passed by a coordinate bench. A cost of rupees 5,000 was imposed upon the Learned Council for the petitioner by the said order. So, raised it to list the present petition.
My lord, I'm appearing for respondent number 5 and 6, my lord. A copy maybe, sir. Copy not given, my lord.
Oh, nothing to do with you. He'll give you a copy, but nothing to do with you. There is nothing to do with you. This is between me and he.
I do not know what
it's 5,000 cost imposed before the appropriate bench.
Lordship, may kindly fix it if possible, my lord. Obliged.
You make a mention
My lord,
before the
my lord.
register. They will send it. Before the court which had dealt with the matter. Before the appropriate bench, will I go ahead? I can't fix bench.
My lord, my lord.
Yes,
This,
today many old faces I've seen. Long time.
this petitioner before Lordship was not paid initially freedom fighter pension, but by our dishonorable court order, ultimately she has got it with arrear. But suddenly after she has, his account has been withheld. Account can be stopped, operationally getting it stopped. Because according to them, the excess payment is made to her. But anyhow, during pendency of this case, my lord, they have, after receiving notice, my lord, they have opened up my account.
Okay, you've done now.
Account. But only one question is, before lordship, it will come later on, because regarding recovery part.
What is the excess payment? How was the excess payment made?
Actually, Lordship, here the main pension authority is CIPA. Central Processing Pension.
Excess payment made to the lady or to the parents?
Lordship?
Excess payment was made to the petitioner
Daughter,
or to
daughter.
her parents?
Daughter of the freedom fighter.
To her. How?
Yes.
It is the finding of the CIPA, not us.
Show me how it was done.
Because presently I don't, but they have annexed one document by which their pension order was modified. They have annexed it in
page 45.
44.
On the basis of that,
45, Lordship got it. 45.
there is a corrigendum. So we had to stop it, but again, then we had immediately on that statement is with me on 26/2 itself. We had opened it. Later operate.
That is fact. They have opened it.
So
what is the mistake of this poor girl? You gave her 13,000 with effect from 2013.
we did not give.
Who gave?
The CIPA.
No, this order is from whom? Government of India.
Yes, we understand. We are only State Bank.
You are State Bank. Where is Government of India? Okay, we'll have it after vacations. Now you're getting your money.
Only one observation, if you're also kind enough, because she's a regular pension from February month, she's not being that they cannot stop it. Recovery part only they can see all these things. Will be this one.
So you're getting it today?
No. From February onwards, again, there regularly, she's not getting pension. It is to be paid.
February which month? February which year?
This year.
February, last February you did not get.
Because this is discontinued. That is what I'm telling.
No. Then they said they have opened it.
We have
opened it.
Our purpose is only to maintain the account.
No. Is the money being transferred?
Money from CIPA.
No, you transfer the money.
Yes.
CIPA is under you only.
No.
Government. So who transfers the money? You transfer.
Yes.
The money comes to us. We just facilitate to her account, which is maintained in one of our branches.
Who is appearing for the central government? CIPA. Registered to list this matter again on 7/4/2026. On which date? Who was appearing?
The appearing, my lord. Let me see.
Nobody.
I think.
Did you see the economy? Mr. R. Devi, Miss R. Devi, Mr. G. Pegu. Who you are appearing for?
G.
Mr. G. Pegu, R. Devi Nagai. Learned CGC shall apprise this court as to why the pension involved in the matter is not being deposited in the account of the petitioner. Inform him. I want that information on 7th.
Meanwhile, Lordship will file our affidavit. No, we have one just to clear out the.
Okay, you file your affidavit.
Every time we become the
scapegoat. Understand. It's a professional need.
Lordship is aware of that case.
It's a professional need.
It will be easier for your lordship to pass an order.
No. I am doing it for him only.
Let us Supreme Court.
Let us have this instruction.
Yes.
You have no objection in diverting the money, but the money should come to you.
Yes, nothing.
Madam, get the instruction. A lady is suffering. You take initiative now.
Obliged.
Yes, why are you waiting for?
29, I missed out actually. I'm appearing for the respondents.
Yes,
My lord,
final opportunity.
my lord, we have received instruction, an affidavit has also been prepared. The instructions we have received is that, my lord, that the he has received the amount for the financial year 1920, 22, 23. Only 21 and 21, 22 is pending. And finance has also approved the same, but the matter is now pending for, the ceiling has not been received. And now, since it was not received earlier, now for the current budget session, it was, my lord, a fresh proposal has been sent for the amount, my lord.
Miss P. Chakraborty, Learned Counsel for the respondent, has submitted that the affidavit in the matter is prepared and was sent for vetting and would be filed on or before.
Under 7 days time.
On or before 6/4/2026. Registered to list this matter again on 20/4/2026. So, Ms. Chakraborty has further submitted that the petitioner is entitled to receive his dues for the financial year
Financial year 2021 and 21, 22.
2020-21 and 2021-22. And the same is pending on account. Same is not being permissible to be disbursed as the ceiling for the same has not been received. Also, Ms. P. Chakraborty submits that incorporating the said information, and affidavit has been prepared and sent for vetting. Also, she submits that the affidavit would be filed on so and so date. Registry to list this so and so. What's your name?
Obliged.
Better now, you can go home.